Madam Chair, I would like to pull just for a brief comment on item 4.
And we'll pull item 4. May I have a motion on the balance?
So moved.
Second.
All in favor?
Aye.
Opposed? Passes on a 5-0. Thank you. On item 3, thank you. I had emailed Mary about this item. I was wondering, my question had been, at what point or how do or when can we stop using or change these chemicals? I mean, we laugh about, the death truck, but, when do we segue into doing something that is not so detrimental to the environment?
Okay, good morning, Mary Mutzai, Commissioner. I guess we would segue into another program when we have a whole lot of money. Because using less toxic chemicals, the organic chemicals, they are very, very expensive, and they need to be applied over and over again. They're not a 1 or 2 time application. Those organic chemicals burn the top of the weed down, don't do anything to the roots, and so we're going back over and over and over again. And with 600 miles of road, we undoubtedly need at least 1 or 2 additional employees and 1 or 2 additional trucks to go out in the death wagon or whatever you call it, to go out and apply these more of the organic chemicals. There's other options like a mulch, in which we would go out and put a couple inches of a corn gluten type of mulch on the roadside, and I think we can all understand the infeasibility of that. Rains would wash it off. Dust, the breezes, the winds would blow it away. So again, that would be continuous applications. I've spoken to a county, Humboldt County, who mows, and the cost of mowing their county roads skyrocketed from the time they used to use chemicals to now that they're mowing. Our Public Works Department doesn't have the mowers, doesn't have the manpower, so we could segue, I think, when we have a whole lot of money. But what the chemicals we're using are some of the safest chemicals there are out there. Roundup, which is, it breaks down. There's no harm. There's nothing harmful to it that we know of or that we claim. The Milestone is not of the type of chemicals that we used years ago that stayed in the soil and sometimes ran down the hillside. So we have changed our program over the past few years to use a very gentle type of spray program.
And Transline?
Transline we use for the yellow star thistle. And that on some sandy loamy soils, it says that it can leach into the groundwater, but I can't think of sandy loamy soils here in this county where we use Transline.
Well, so it's all money.
Yes, it's all money.
I'm having a hard time with this because I know we have more of our growers moving towards organic ways of growing crops and vineyards. The gardens that we're using that are formed, the community gardens in the county. And the other part of me understands, but I do drive along county roads and see signs that saying do not spray, and I'm assuming that we're not where there's signs that say do not spray.
That's correct, and just for the listening public out there, if they do not want the spray applied in front of their house, they must contact the Public Works Department, and Public Works will put them on a list, and then they also must put signs out in front of their house. So yeah, we will not spray them if they say do not spray, and then Public Works may have an arrangement with them. I don't know their program. The homeowner, the property owner may need to control the weeds, keep them down at a specific level.
So I'll move the item because I think we should spend taxpayer money wisely and efficiently and effectively and not incur waste. And quite frankly, if we all went organic, we'd have mass starvation on the planet because you can't produce the yields you need to feed the billions of people we have. And they put a lot of research into these products now, and the herbicides and pesticides are becoming much more environmentally friendly. We have a good program, and I think we should continue with that program. So I'll move the item, Madam Chair.
Do I have a second?
I'll second that motion.
Okay, for a discussion, Supervisor Walensky.
I just had one question. I'm interested in the active ingredient of Milestone.
If you give me a minute, I can give it to you. I don't have it memorized, but I do have a label right here in front of me.
All right, and while you're looking that up, I'll just say that an increasing portion of the world's food supply is actually being done with less and less chemical and in fact, the expenses for many farms, the biggest rise in that is based on the oil and other bases for the chemical applicants. And so many, including grape growers in this county, are finding that their costs are saved and the health benefits improve at the same time by going organic. This is not true of all crops, but it would be good to base our comments on the science of the moment, and most of the world's actually headed in a cleaner and less expensive and less chemically dependent approach to food supply, partly because people have been concerned about the high levels of cancers that are thought to be a result of the consumption of combinations of these applications. That's on the food side. Now, roadside, what's our active ingredient so we can take a look at what we're putting out there?
Are you ready for the active ingredient?
I am.
Excuse my mispronunciation. Trilsopropanylammonium salt of 2-pyridine carboxylic acid.
Actually, could I get that in writing? I used to be kind of good at spelling these in the 6th grade, but that one blew me right by me.
Excuse my mispronunciation.
I'll just take it later, but I would like to check into it.
I can email you the active ingredient and the label if you'd like that.
That would be
I'd
great.
be happy to do that or provide you a hard copy.
Email's fine.
Okay.
Anything else, Steve?
Nope, that's it.
Mary, I have a question, and maybe Tom might be able to answer it if you can. Are the MSDS sheets available to the public at the counter at Public Works, or where would they be able to pick these up? I think that's what Steve is after. He could get MSDS sheets for all of the chemicals.
The MSDS sheets are kept on file, available at the request of the public.
All right.
It's part of the conditions of us being able to use this chemical.
Right.
And just to follow up on that note, we do send copies of the labels and the MSDSs to all of the post offices that have rural delivery, so that their carriers know that the spray has been applied and that there might be a residue on the mailbox. And so we do provide them to the post offices every year. But we can, anyone that cares for a material safety data sheet or a label, we can provide it. And they're also easily available online. We could direct a person to an online source, but we can do hard copies.
I'd like to make a comment. Supervisor Callaway, I think that we can be 99% assured that any product that is on the market now has been scrutinized for the last 25 years by various state agencies. My wife used to write
other ways to deal with the issue. And we had a meeting here, Brian Moss gave a few years ago on the different options available to property owners regarding the star thistle. And I'm not saying we're all going to go out and buy the ladybugs or whatever those bugs were and put them on, because it might take a long time and star thistle spreads. I just think we need to be cognizant of the change in expectations of the public, and we shouldn't just say this is fine, it's been tested, because these chemicals do have an impact on the environment, on the people, and on the soil. So I would just like to see Calaveras County moving to that way and maybe giving options to people, and then giving options to the county for what we use on the roadsides for Calaveras County. So I will now call for the question. All in favor?
Aye.
Opposed? Passes on a 5-0. Thank you.
Thank you. In the future, I will put this item on regular agenda because this is the second year in a row that it has been pulled from consent. So I will do it on regular agenda.
So should we just play the same tape next year?
Yes.
No, okay.
Thank you.
Thank you. I'd like to move to item 4.
Good morning, Colleen Tracy, Health Services Agency Director.
Colleen?
Russ
Yes.
had a question.
The only reason I pulled this, Colleen, was just that it struck me as being a little bit overly officious on the part of the board to have to review something like this at $200 when I see your signature and Jim Jones's signature and Jeannie Boyce's signature on this. I mean, we give department heads frequently discretion of approving $5,000 contracts. Why? I mean, I'm trying to get my head around this. This requires an awful lot of staff time to prepare these reports and things. So
I appreciate the staff time on both the department and on the other, the county administrative office, county council, etc. This is an agreement that is with, actually is with a state agency, the University of California. It's not an agreement to expend funds, it's an agreement to accept funds. It's a contract for staff to attend and be reimbursed for some specific travel costs. With the state contract comes a lot of boilerplate indemnification, etc. language that was excessive relative to the amount of the agreement. I agree. However, it's my understanding that for revenue contracts, it requires board approval, and that the authority of the department head is for contracts to expend funds. And so we were taken aback, quite frankly, by the amount of boilerplate, indemnification, other types of paperwork that came with it, and that's why it was brought to the board.
okay.
May I just elaborate on that, because I was taken by the same thing, but this grant of $200 and some came with about 12 pages of fine print from the state in which we promise, the county is making extensive promises to indemnify them for a variety of things. So regrettably, we don't have an alternative but to bring it to you.
I think Russ's point's well taken, and maybe there's something that we can do in our codes to allow the CAO to sign off on something at this small amount, but that's just something.
I understand and agree with the concern.
Well, that's where I was headed. It just seemed like this is really costing us $500 to process a $200 grant.
I absolutely understand.
Good point.
I think
Would you like to make a motion,
we should
Mr.
refuse the
Thomas?
money. Yes, I'll move this item, Madam Chair.
I'll second.
All in favor? Aye. Opposed? Passes on a 5-0. Thank you. I'd like to move to public comments. If anyone has something they'd like to address to the board not on the agenda.
Good morning. My name is Bonnie Newman. I'm from Double Springs, and I'm not here today to talk about the authority. I'm here to talk about something else, and that's IHSS. In fact, I was attending a training put on by the Rural Authority, and they had I provided them some information that they didn't know about yet. And so at the bottom of this little handout, I'm going to get to that information. First of all, once in a while we have a little bit of information that helps us understand things, and this is something that I got from the union, and it was how IHSS actually saves money to the taxpayers of California. Each recipient receives about 80 hours a month, and that equates to between $800 and $1,000 a month. Under IHSS, that's about $10,000 to $12,000 a year. In a nursing home, of course, $3,000 to $5,000 a month equates to $36,000 to $60,000 a year. So you can see the savings is like a quarter. This is how IHSS makes money for Calaveras County. Up until the big budget thing last year, every 17 cents that Calaveras County puts into this program generates 82.5% in state and county and federal money. Now their percentages have changed because the state cut its funding, and through the stimulus money, the federal government kicked in the difference. Now, you all may not know this, but before Barack Obama was elected president, he actually spent a day in Alameda County as a health care worker. And I think that's what tugs his heart when right now what our governor is doing is kind of holding that hostage, because apparently if you get on the governor's website, and I'm governor.com or whatever he is, he's proposing to the federal government, California's going broke. Either you give us, and there's like so many trillion or billion or this big amount of money, or I'm going to cut these programs, some of which you hold very near and dear, one of them being IHSS, to the tune of 87% reduction across the state. To Calaveras County, that means we have about 260 recipients, 260 health care providers. We would end up with maybe 35 recipients, 35 health care providers, the tune of almost $250,000 in revenue would be lost totally. 225 people would suddenly be unemployed. Now we're going to have to get services to feed our family and pay our bills. What is the cost? Goodness sake, what is you can generate so much more, not only for employment, but for keeping these disabled, handicapped people from becoming a part of the system. The system doesn't work at this level. The further away you get into it, the less it works. We need to keep these people in their homes as long as they can. It's the only hope they have. Don't make it so miserable. Don't let it become so miserable that we want to die instead of go on. It's desperate. Any comment?
Thank you, but now this is all the counties are facing this and are very sympathetic to this issue. Thank you very much. What, do you have to see us, Gary, to talk?
I can't stay away. Gary Caldwell, Valley Springs. Good morning, Madam Chair and members of the board. I have an article here that I'm looking at that was in the Calaveras Enterprise about a week ago. It has to do with the recent policy on Open Records Act that the board discussed. And I think most of the board members know that I'm a big fan of transparency in government, even though I've worked, I shouldn't say even though.
Yeah.
I worked 40 years in one form or another for government. And I think what the board is doing is the correct thing, as I've said over in the past with respect to the Sunshine Law. You know, its anniversary is coming up next month. I think it's appropriate that you're taking action. And as I've said before, that if you don't have the availability to the public of open records with respect to the Sunshine Law, then, you know, you cast a shadow on it. There's just more people that are going to be unhappy with government. As Supervisor Walensky said, according to the newspaper here, it's exactly policies like this where we're thinking about protecting ourselves that gets people who have the legitimate right to know and get ticked off. And that's right. The people have the right to know. I have asked for the ability to look at a file here one time. I'll never forget this, where the lady on the other side of the counter said, "Why do you want to see that?" And I don't think it has, I'm sure you all know, that has nothing to do with offering me the file, the public document. But yet that person was apparently doing this without training, and I'm glad to see that there will be training associated with this. And also, and I know Mr. Jones is also a big fan of transparency in government, and his staff I'm sure has done a good job on the policy, that it includes, according to Supervisor Callaway, that it includes a disciplinary action if an employee deliberately thwarts the ability of the public to see a public document or receive a public document in accordance with this new policy. I'm glad to see that. But in order to make that work, you need to have the training associated with that. I once said to Mr. Jones that, you know, it may be easier just to list the exemptions because there are not that many in the Open Records Act. You know, with respect to the employees' training, it may be easier to list exemptions and say if it isn't one of these 7 or 8 exemptions here, it's a public document, and the people have a right to look at it and get a copy of it. And I applaud you for taking the action to put this down in a policy, and hopefully you will enforce it vigorously. Thank you.
Thank you, Mr. Caldwell. Anyone else?
Good morning. Brian Keene, San Andreas. Actually, I'm sort of before you because I think this county has a problem that we need to resolve ASAP. As you know, you already saw the housing element. The housing element document also went through the Planning Commission, and then it went on to Housing and Community Development. When we got the letter back from them with the initial review, it referred to some changes that were made to the document. And I said, changes? What changes? Because the public had already seen the document also. But none of the public had ever seen the changes that were made. So I got a hold of Mr. White, and eventually, after 3 trips to the planning department, finally got a hold of the documents, and because he says, oh, well, they're not significant. And yes, in a sense, his comment is correct, but it also depends upon your perspective. The other thing that sort of hit me is it's not, I don't know if any of you are aware that they did make some changes to the housing element document, but did not run them through the board or the Planning Commission. Anybody aware of that?
It's your turn, please.
Oh, so anyway, so part of my comment is the fact that the public is not being apprised of changes in our housing element, which they should be. And I appreciate Mr. White's keeping the process moving, but this document, our old housing element, has been sitting on a shelf for the last 5 years collecting dust, and now all of a sudden it's hurry, hurry, hurry. I have a problem with that. So if you're not going to take and let the public know that you've changed the document before it's actually adopted, then there's something wrong there. So Mr. White is keeping the process moving, but it's also not up to him to determine what's important and what's not important, so the rest of the board and the Planning Commission can see what changes have been made in the document. I don't know, like I said, I don't know if anybody's aware that changes were made. We now have a stakeholders meeting coming up, and we've been told that they will probably have, the Mintier will probably have some documents already written, but we don't know whether we're going to be able, whether the stakeholders group is going to be able to comment on them or not. The thing is, this is our housing element, and we're going to have to live with it for the next 5 years. And if we don't go through the normal process of public review, Planning Commission review, Board of Supervisors review, then I don't think we're doing the county justice. Thank you.
Thank you. It will not be approved without public review.
Good morning. My name is Arthur Lopez. I live in Valley Springs, and for about 2 years now I've been trying to get somebody to look at my situation where I live. There's a tree. It's one of those big, it's about 60 or 70 feet tall, and every year it's leaning more and more. When that thing falls, it's not on my property line. It belongs to my neighbor. I already contacted him. I says, would you please knock this thing down before it causes more damage? When it falls, I will probably lose 3 oak trees, block me in, which I won't be able to get out till they clear that thing out. And, you know, it's raining. I'm keeping an eye on it with the winds and everything else right now. If I hear a bang, I got to call somebody, come and clean it up. I'm going to have to get the insurance involved, and, you know, because I won't be able to get out. The other concern I have people come over to my house, they park. Every time I go by there, I'm looking at this tree. If I see it crackling, I'm hitting the throttle to get out of the way, because it'll kill somebody if hopefully it doesn't happen. I want to know who can I contact to come and see my situation and take care of this before something drastic happens with this tree.
Mr. Lopez, is the tree on county
on my
property?
property.
Is it on the neighbor's property or county property?
No, neighbor's property.
I will have, if you could get your phone number to the clerk, we will have someone give you a call.
Okay.
Thank you. I don't want you to give your number publicly.
All right.
But if you could just write your
further development of those documents. And then on Saturday the 27th, we will be holding some additional open houses or an open house for members of the community to come in and again provide additional input. I have a number of the other additional cards that I will leave here at the podium, and if you have any questions, I'd be more than happy to answer them.
Thank you, Mr. McSorley.
Tim, at a recent meeting, we discussed and spoke with your consultant about the method that we'll be employing for voting on this. If you recall, they said that they only had a limited amount of those clickers. Were they successful in getting more?
Yes, we're looking at obtaining as many as 500.
Good. Okay. Perfect.
Thank you.
Thank you. Are there any other comments the public would like to make?
I just have a correction. I said it generated $250,000 in Calaveras County. It's actually $2.5 million. I forgot a zero.
Thank you.
And a lot more than I thought.
Thank you.
Darren Spellman, District 5, Rancho Calaveras. In regard to the meeting on the 23rd, where there may be clickers involved, I have a number of people that are concerned about, at the last meeting in August that took place, there were people that were allowed to participate in the clicker vote who did not even reside in Valley Springs, not just Rancho, but these were people from Moke Hill, wherever, other places in the county that weren't even in the Valley Springs area that were allowed to vote on this. So I know there's some people that are talking about bringing legal action if those people are allowed to vote on something that doesn't pertain to them directly. That's another issue. So just throwing that out there so you get a chance for Tim or whoever to think about who they give those to. There's some people that are fired up about that. In regards to, there was a guy that came here last week and talked about a land use issue where he lives on Surrey Road in Copper. I made a visit out there this week, and I was astonished to find that on the property in question he's talking about, I counted 17, and there might have been more, but what I could see with water on my windows looking through my car, 17 I counted for sure with no doubt. These were either berms for embankment turns or jumps. So 17 combo of banks and berms jumps together. And these were not the kind that you could make with a shovel. They were the kind that would use heavy equipment to make. So in my estimation of things, with the brief knowledge that I have and the research that I've done, I would say that we have several different issues here. Number one, in terms of a grading violation. Number two, in possible noise ordinance issue. Number three, property use designation issue, and also an environmental issue in regards to the dust that he talked about that was being thrown onto his house and his cars and things like that being next door to this. I want to make it clear to the board and anybody who's watching this, I had a gentleman approach me last week about a property rights issue. I want to be very clear. I am very in favor of people having the liberty to use their property how they would like to. That's a personal liberty granted to them by our laws. However, I also believe that people should follow the laws as they are written. If they have a problem with the law, then they need to go through the, I'll quote Supervisor Walensky, who said a couple weeks ago the term he used was fair and democratic. If somebody wants to change the law, either for or against that type of a use, it needs to be a fair and democratic process. But at this time, this guy said he's had this ongoing problem for 3 years, and Russ Thomas was out to his property a year ago, and he's still dealing with this. And there's several issues I can see here, and I'd like Russ to step up to the plate and be a supervisor. Take care of this guy. Thank you.
Thank you for your comments. Is there anyone else who would like to address the board? Okay, we're going to move to item 7. Minute order for final determination of tax refund claim of Alan Roberts. I have a question before we start. Mr. Thomas, when this item last came before the board, there was a lot, you were not here, there was a lot of documentation. Did you read the file?
Yes, I did.
Okay, thank you.
Madam Chair, could I just introduce the item? I don't mean to interrupt, sorry.
No, that's okay. I just wanted to clarify that. Mr. Jones?
Technically, it's brought to you by me at your direction. Mr. Roberts was here back in October and presented his appeal, which resulted in a 2-2 tied vote by this board. He's asked to come back for further hearing, and that's how we happen to be here today. I just wanted to set the stage for the hearing, because I think it may be helpful to the board. He appeals to you on the authority of a section in the Revenue and Taxation Code, is Section 5096, which I've given each of you a copy of. And the appeal is to argue that under one of the 7 provisions of that code section, he's entitled to a tax refund. This is distinguished from an appeal over a determination of property value. This board has established an alternate process. You've appointed an assessment appeals board to handle appeals on property valuation, and that this is not a substitute for that process. The appeal from a decision by the assessment appeals board goes to the court. So the point is that any appeal here has to be under 5096, has to meet one of these 7 criteria for what amounts to extraordinary relief. Some of these obviously don't apply. If, for example, A is paid more than once, I don't think that's the argument here. So that's the basis, the sort of the roadmap for what I believe Mr. Roberts is requesting this morning. That's all I have.
Okay, thank you, Steve.
I'd also like to try to, before we begin this, correct the record in one regard. There's a letter dated January 5th, 2010 that's part of the attachments that the board has, which erroneously identifies me as having made a couple of statements that were actually, I believe, made by Supervisor Toffanelli.
That's correct. I contacted these to apologize for my error.
If I'm not asked for that, I just want to make sure the record is corrected before we begin.
Okay. Thank you. Mr. Roberts, if you'd like to please identify yourself for the record. And we do not need to reiterate what was done prior. Mr. Thomas has read that. You will stay focused on the code 5096 and any new information. Thank you.
Thank you.
Please proceed.
On your agenda. I'm here to speak about...
Could you identify yourself, please?
Sorry, my name is Alan Roberts. I own 2 pieces of property on Pinecone Drive in Arnold, and one of those pieces of property, 1838 Pinecone Drive, is the subject property. California Revenue and Taxation Code 5096 was apparently passed by the legislature in order to provide a remedy for certain situations of excessive taxes paid, where the assessment appeals process does not provide such a remedy because of some of the rather strict and rigid rules that apply to the assessment appeals process that don't apply to the 5096. In particular, I'd like to focus on tax code, the clause D of tax code 5096 that provides that taxes paid before or after delinquency shall be refunded if certain conditions are met. Let's shred that out in terms of the specific conditions. Erroneous property information supplied by the SSC. When he executed the quitclaim deed in August 2006, Shane Crow gave an address for Kathy Jones that had not been valid for approximately the time he initiated the quitclaim deed, and therefore the SSC at that time, an invalid address for the new owner, such that the county cannot successfully contact that new owner, is certainly erroneous property information. By reason of excessive assessment attributable to that erroneous property information. Well, was the $115,000 assessment that occurred as a result of that quitclaim deed excessive? Yes, the assessor's office provided ample evidence of that. When it was protested in May 2008, it was immediately cut to $60,000 from $115,000 for the period 2007-8. And because of a filing error in the records office, that was done with absolutely no evidence presented by the SSC whatsoever. Then, 2 months later, when the improperly filed information was available under a successive protest, that $60,000 valuation was further cut to $8,000 in the period from April 2008 forward. So yes, the assessment of $115,000 was excessive. Is that $115,000 assessment attributable to the erroneous information? Well, Kathy Jones filed a protest once she knew that she was the property owner and understood the value of the property. That protest, however, was untimely for 2006-7 under the assessment appeals rules. If she had not, if there had been a proper address, Sue Freeman and the tax collector's office and I were actively seeking her in 2006 and early 2007. We would have been able to make contact with her, she would have known she was the property owner, and she would have had the opportunity to file a protest in a timely fashion. So yes, that $115,000 assessment standing, continuing to stand, was directly attributable to Shane Crow's action in providing that erroneous information. It says that any taxes paid before or after delinquency shall be refunded. Note, before or after delinquency, there is no untimely issue in 5096D. And yes, the taxes were paid. They were paid by me in April 2008, immediately after I acquired the property. And the fact that I paid those taxes is the only standing that I require under 5096D in order to bring this claim forward. So we have all of the elements of Clause D, Tax Code 5096 met. Well, if that's the case, then what should be refunded to me? What would the assessment have been back then if that $115,000 was not allowed to stand? Well, that's got to be reconstructed somehow. That's up to you to decide what it would have been, I believe. But we can look at that by looking at the assessed values that have been in play across that period. Went from 6485 to 115 to 60 to 8,000, as you know, as you understand from the history of it. Let's take those one at a time and look at them. Let's take the easy one, 115,000. We've already talked about the reassessments that occurred, and I think it's noteworthy to note that through the entire appeals process, nobody in the assessor's office or on the appeals board has ever offered one word, either verbally or in writing, in support of a valuation of $115,000. So I think that one should be ruled out. Let's take the one at the bottom, the 8,000. That's the one that is in effect today on the property. It occurred in August 2008 reassessment that I described to you. It was placed retroactively in effect back to April 2008. The onset of my ownership, which was the period for which I had standing under the assessment and the assessment appeals process. And it was derived from what I paid for the property. $1,000 to Kathy Jones, $4,000 to settle the CCWD bond owing, and $3,000 in taxes. Well, why shouldn't that then be the valuation that would have occurred in 2006 or 2007? Well, the reason is because if we projected this transaction back to 2006, the amount owed in taxes would not be $3,000, but less than $1,000, actually closer to $700. So it suggests that although $8,000 would not have occurred in 2006 or 7, according to this logic, $6,000 would be an appropriate one. Let's take the other, $60,000. This one occurred as a reassessment made in June of 2008, based on comparables in 2008, and it was replaced two months later by the assessment of $8,000, as I described to you. However, on October 21st, 2009, in the assessment in front of the Board of Equalization, this $60,000 valuation for the period from July 2007 through March 2008 was reaffirmed. It was reaffirmed by that Assessment Appeals Board. And that reaffirmation included two comparables, again, from 2008. Now, I think I would be very reasonable in saying all of this evidence was presented based on comparables in 2008 or evidence presented at the Assessment Appeals Board in October of 2009. That couldn't possibly be a part of an evaluation in 2006 or 2007. I think that would be a reasonable request on that part, but I do not make it. Because if I made that request, I would be implying that that $60,000 valuation has merit. And I believe it has no merit at all. And so I want very much for you to understand the evidence that was presented at the Assessment Appeals Board and the evidence that I have gathered since then as a result of that. In the Assessment Appeals Board, Randy Gomes put up this document minus my scribblings on there. I apologize for those. The discussion with Ron Marwin of the Calaveras County On-Site Sewage Department about lots of this type that exceed 40% grade said that those lots are eligible for an experimental drip septic system. He then went on to issue the coup de grace. Not only that, Not only is it eligible for an experimental system, they have never turned one down. He went on to say, we believe that lot is buildable. We made a mistake on the $8,000 assessment. We affirm the $60,000 valuation. Well, I was completely blindsided by that in the meeting and caught completely flat-footed. I walked into that meeting with the assessor's office having for the last 15 months had an assessment out there of $8,000 that basically seemed to, in my septic engineer's evidence, that it was an unbuildable lot. Here was evidence to the contrary.
Could you please state in with 5096 and any evidence that you think applies to this? I mean, because we've done this.
Well, if you agree that I'm entitled to a refund under 509, I've demonstrated that the premises of 5096 have been met, and therefore you have to decide what's appropriate to refund, all of it, or is there some valid valuation? I would say, you shouldn't be obligated to refund all of it, all of that exceeds a rational assessment. So I think you have to decide what a rational assessment is. That's the evidence I'm presenting. I think that's reasonable. Please let me do so. All right, so again, I'm sitting there, while I have a certain disdain for Randy Gomes' credentials as a septic engineer in Calaveras County, I have no such disdain for Ron Marwin. I've interacted with him. He's very knowledgeable. He's very thorough. And I'm sitting there in that meeting thinking, did my septic engineer make a mistake? Did Ron Marwin sit with Randy Gomes and demonstrate a way that this experimental system could be applied to this lot? Is it buildable? Am I making a mistake in combining it with my lot next door and just using it for the driveway? Should I develop it? So I left that meeting and went to contact Ron Marwin to pursue this a bit further. Imagine my surprise when he informed me, we didn't discuss any particular lot, we only discussed steep lots in general. Well, you didn't discuss the fact that the lot was pie-shaped, restricting the septic field area? No. You didn't discuss the seasonal drainage that there's a seasonal drainage along the property that requires, this is a typo, it actually requires a 25-foot setback? No. I said, well, Ron, wouldn't that matter? He said, of course it might matter, it might not fit. I said, wait a minute, Randy Gomes says you've never turned one down. He said, well, we've never turned one down that fit. I guess I should have said that it has to fit. They don't submit them. They don't go to the expense of submitting them if they don't fit because they know we'll turn them down. And he recommended that I get my septic engineer to do a scale drawing of the field area. All right, this was right before the October 28th meeting. Across that weekend, I developed two pieces of information. This is a memo from Dale Pilgrim, a resident of Pine Brook, to the Pine Brook Homeowners Association that discusses in 2005, based on issues they had with that lot, the Homeowners Association Board of Directors had Steve Buckley do an assessment of this lot. Steve Buckley is a senior, experienced, qualified, licensed septic engineer in this county, well known to your on-site sewage department. And he walked the property with Dale Pilgrim. He noted that severely downsloping pie-shaped lot with a seasonal drainage down the side. It exceeds 40 degrees, which requires an experimental system, and there's simply not enough leach field space on the property. Across that weekend, before the board meeting on October 28th, Al Armstrong, my septic engineer, who likewise is a senior, experienced, licensed septic engineer in this county, well known to your on-site sewage department, did an analysis, drew up the diagram that Ron Marwin suggested. He noted the triangular shape, the seasonal drainage, did a calculation, said it required, for this experimental system, required 250 feet of field, and only 140 feet was available, was 110 feet short, concluded it's not buildable. I presented both of those in that meeting on October 28th, but it was under time pressure at the end, and I did a very poor job of presenting it, and I apologize for that. At the end of that, two of you voted in favor of my petition, two voted against it. What did I do at that point? Well, I walked out of this meeting, and I walked across the on-site sewage department to see if I might be able to sit down with Ron Marwin, show him the diagram that had been the attachment to the memo that Al Armstrong made to see if he might discuss it with me. As luck would have it, both Brian Moss and Ron Marlin were there. Both of them graciously made time available, sat down with me, and went over this very diagram. Looked through it in some detail, discussed it in some detail with me, and concluded the same thing the other two septic engineers concluded: there's not enough field space. I said, look guys, you're both employees of the county. I don't want to quote you out of context. I don't want you to put you in an awkward position. Okay, but I would sure like some words from you that you would authorize me to say in front of the board. And down at the bottom are the words that I hastily scribbled as they said them. When you get issued me, you get issued a left-hander. They're difficult to read, but basically it responded to, well, to get an official response, it would need to be officially submitted for review. But based on the drawing submitted, it appears, part of that's missing, it appears that a two-bedroom system, which is the minimum acceptable, would not fit on the lot, even with the best engineering solutions available. And then on the upper right said there's a lack of available area for leach lines. So there you have it, 4 senior qualified septic engineers in this county, all saying that there's not enough leach line space to apply this septic system. One of those 4 being the one whose name Randy Gomes dropped in that meeting in support of his premise that the lot is buildable. It's not a buildable lot. The $60,000 valuation likewise is not valid. And so I'm asking for your vote. I'm asking you to conclude that my claim under 50960 is valid. Second, I'm requesting that you conclude that the likely valuation for 2006 and 7 would have been either a continuation of the existing 6485 or the $6,000, which would be the extrapolation of my transaction back to that time frame. If you do not vote in favor of this, if you vote no, you're saying that I don't meet 50960, or you're saying that $115,000 is a valid valuation for that property in 2006. If you do choose to vote no, I would ask that you show me the courtesy of telling me which part of 50960 is not met, or look me in the eye and please tell me that $115,000 is a valid valuation for that property in 2006 and 2007, in your opinion.
Thank you. Does the board have any questions for Mr. Roberts?
Mr. Roberts, at the onset of your comments, you said that it is your intent to eliminate the boundary line between your residential lot and this lot and use it for driveway.
I have not completed that. It has been filed.
Okay.
It is not developable, but developable. You could never get a septic approved by the system, and it will never even be tried because the two have been merged. I'm going to use the first 25 feet of that lot for a driveway, and the rest of it's just going to be maintained for fire safety and be a privacy buffer. And that's fabulous to me.
Okay. Just for the purpose of getting my head around all this, what will be the total size of the combined 2 lots?
Combined 2 lots, just over a half acre, I think, 0.6 maybe, roughly that.
Okay, so I was trying to read on that one slide that the existing one is about 0.42 acres then, the one with the home on it?
It doesn't have a home in it.
Oh, there was a sketch of it. Yeah, okay.
That was just a rough estimate. 0.4, it may be 0.7 acres and 0.4, 0.3. The triangular shaped lot is smaller. Definitely, I think it's around 0.3.
Okay. All right. That's all my questions.
Are there any other questions of the board? Mr. Jones, did you want to...
Well, I just wanted to point out that I'm recused myself from any involvement in Mr. Roberts' claim and the merits of his claim, so I'm not in a position to answer any questions that you might have, but the assessor's office is representative if you have any questions.
Okay, thank you. I do have a question of the assessor's office.
Liz,
from the County Counsel's Office representing the assessor.
Since the properties are now combined in one, Mr. Roberts have the option of then going to the assessor and asking for a reevaluation of the property based on, instead of two parcels, they're one parcel? Thank you.
I'm going to have the assessor answer that particular question.
Okay, thank you.
Madam Chair, honorable members of the board, Leslie Davis, acting assessor. As you all know, the filing of a map does not trigger a reappraisable event. So the fact that he merges the lots legally would not trigger a reappraisal. He can, however, come to our office and request a review of the value. That would be a year-by-year review, because once his base year value has been established, and at this point it's been established by assessment appeal order, that value is not subject to review by our office. They can only go to Superior Court.
While Ms. Davis is up there, I'd like to ask her a question about the notice that was sent to the former owner. When I first read this thing, gosh, I think it came before us close to a year ago when we first started reading about this, that there was, it seemed very much to me like that there was an overt effort on the part of this gentleman to withhold the information or give the wrong information about where the property owner could be notified or located. Has that been fleshed out
Well,
to any
Supervisor
extent?
Thomas, let me tell you that's immaterial. He recorded her address on the official record. We are charged with using the address on the official record. Unless a property owner contacts us, it changes that address. So, given whatever Mr. Crow did, Ms. Jones' address had nothing to do with the property, which is what he is claiming under 5096D. And I might add, he's not giving you all parts of 5096D. If you had them, you wouldn't be following his line of logic. Her address did not affect our valuation. And in point of fact, he testified here today that Sue Freeman contacted her in November of 2007. As you know, the final filing date for an appeal was November 30th. She was contacted in plenty of time to file a valid appeal.
Well, that's just not true.
No, Mr. Roberts, we're not discussing that. We've asked a question of the assessor's office, and they're responding. Thank you. Ms. Davis, please proceed. Ms. Davis, please proceed.
The only other thing that I would comment is 5096D. Mr. Roberts culled information from that code section. I'd like to read it to you now. 5096D reads, any taxes paid before or after delinquency shall be refunded if they were, and here's D, paid on an assessment in excess of the ratio of assessed value to full value of the property as provided in section 401 by reason of the assessor's clerical error or excessive or improper assessment attributable to erroneous property information supplied by the assessee. So, Supervisor Thomas, in answer to your question, a mailing address of a property owner who may live out of the country is not erroneous property information supplied by the assessee. Moreover, this code section says, in excess of the ratio of assessed value to full value as provided for in section 401. 401 says all property is assessed at full cash value. Now, a little bit of history. I mean, some of us were around before Prop 13. Before Prop 13, property was assessed at 25% of market value. 401 says it's now at full cash value. This property was assessed at full cash value.
Any other questions, Mr. Thomas?
Julie Moss, again, if I might just add something else about 50960. Mr. Roberts asked the board to say, either tell me that the value is wrong or tell me that I don't fit 50960. And I would really like to assert that in my reading of the law, what he's asking for is revisiting a valuation of his property. And I would assert he doesn't fit into 509060, that his remedy for disagreeing with the Assessment Appeals Board decision is to go to court. Yes, he does need to file a claim for refund as a procedural step. He could have checked a box asking that the finding of the AAB board be counted as a claim for refund, and he didn't have to come to the board at all. But that is his remedy. There is a case and further cases that discuss it, that make it very clear that overpayment of tax, resulting from an alleged excessive assessment are not recoverable under 5096 at all, under any of the subsections. And that case is Los Angeles, the way it's quoted here is Los Angeles, et cetera, Corporation versus Los Angeles County, but the citation is 22 Cal App 2nd 418. And I believe what Mr. Roberts is doing here is asking the Board of Supervisors to, in essence, sit as a second assessment appeals board, and that is not proper under 5096. Thank you.
Thank you. Does the board have any other questions on this?
Any opportunities?
I'll give you 1 minute.
I contacted the county counsel's office ahead of time to ask if there was any recommendation council was making, so I might know it. And I was told that there was none, or that any that there was on the website. I went to the website, there was none. So I'm appalled by having this walk forward and blindside me. But again, the erroneous information denied her the due process of the review of that assessment. And that assessment has been clearly shown to be not a buildable lot. 4 qualified septic engineers in the county have provided words that support that. And no one has provided any information on how a septic field can be applied to that property. And yet $115,000 valuation is being allowed to stand simply because erroneous property information denied Kathy Jones the ability to respond. Said November 30th.
Okay, thank you, Mr. Roberts.
Notice went out on April 12th.
Mr. Roberts, I gave you the courtesy of explaining. Thank you. Okay. If there's no other discussion by the board, as a courtesy to the public, though this isn't really your issue, I will open it up if the public has any comments to make. Thank you. It's at the board level. Do any of the board members have a comment on this they'd like to make?
Well, I guess
All right, Mr.
I'll make the same comment I made before, because I'm for granting the appeal. Clearly, the reassessment that went from $64.85, I believe it was, to $115,000 was not, I don't want to say valid, I guess, but was not a appropriate assessment. And, you know, I'm trying to remember from the earlier meeting, and then the assessor took it down to $60,000. So the assessor agreed the 115 wasn't valid. And then the assessor took it down to $8,000. So the assessor also agreed that the $60,000 wasn't valid. And in my opinion, you know, a lot of sort of...
And what the Assessment Appeals Board decided on the property, which is $60,000. And that's what is before us.
Do you have a comment, Supervisor Walensky?
I think it's pretty difficult to unscrew a mess like this. But the fact that that people in good faith acted on bad information, and that some of that information some of the bad information or the withholding of good information was intentional, seems to me something that there ought to be some remedy for. And I read this 5096 as the vehicle through which a mess like this could at least somewhat be corrected. And I welcome the opportunity to try to get some justice in this thing, and therefore agree with Supervisor Tryon's remarks and hold to my original position on the subject.
Just an additional comment. I mean, it's not $60,000 because the assessor has taken that and reduced it again to $8,000. So, you know, the assessor has basically unwound just about the whole thing, because probably if you take the $64.85 and apply the cost of living increase up to the present time, you're probably around 7 or something. So, you know, the assessor of its own volition has basically unwound the whole thing as being an inappropriate assessment. And this gentleman has paid the taxes on that inappropriate assessment and is basically asking for a refund. And I think that, you know, just in equity and fairness, that's only appropriate, it seems to me.
So I have a question, Mr. Tryon. That's just on the taxes. On the assessed value, are we then going to become an appeals board to decisions made by the assessment appeals board? The assessment appeals board
well, we were
is not. Well, the decision was made by the Assessment Appeals Board. So if someone doesn't like their decision, then do they go in through another door to get that assessment changed? And what?
Well, I mean, we can meet, I guess, in either capacity, although we have now removed ourselves as the Board of Equalization. And he's bringing this back. I'm assuming, since it's on the agenda, County Council has basically said it's legal for the board to entertain the request.
No.
You're wrong. The board may agree with council that this doesn't apply, but if this does apply, then obviously the board has the ability to vote on it, or it seems to me it wouldn't be here.
Okay.
Council shouldn't have allowed it to be
No.
here.
Mr. Jones, could you please remind the board what the issue is before us?
Mr. Roberts asked to be heard on 5096. Implicit in that is the claim that he can establish one of the 7 bases.
And he's trying to establish the fact that there erroneous information.
The fact that I put it on the agenda was at your direction and implies no approval by my office whatsoever. It's simply.
Well, I understand you're not making a recommendation. Are you telling us that we cannot legally act on the request?
The only comment was that the appeal process, the Assessment Appeals Board was created to substitute for the previous procedure, which had those matters come to this board, sitting as a Board of Equalization. So you've replaced yourself with the Assessment Appeals Board and taken yourself out of the process for
But we are the ones that heard this as the...
No, this was the Assessment Appeals Board.
Huh?
The process now is...
Right. But we heard this initially as the Board of Equalization being the Board of Supervisors when Mr. Roberts first came before us.
In October, this came to the Assessment Appeals Board earlier in October, and then came to you under 5096 as a Board of Supervisors.
Okay, so under 5096 as the board, we can vote on this.
Of course you can vote on it. My only point was that the process is if it can't be resolved by the assessor's office, the appeal goes to the Assessment Appeals Board and then to the Superior Court on issues of valuation. For
$1,000 or $1,200, it would be absurd to tie up the Superior Court for something like that. I mean, you talk about a waste of resources, that would be a horrible waste of resources, in my opinion.
I can't comment on that. My only role is to tell you what the process is.
No,
Okay. Mr. Tupinella, did you want to?
Leslie, you testified here that under 5096, erroneous information, an address does not qualify that. If the applicant or the person that filled out the quitclaim deed gave the address that the last address that he knew the property owner or that person he was quit deeding to lived at, whether they lived there or not, he's testifying that that's the information that I have on that person.
Well, that's true. Let me just take you 2 more steps further. The second step is that we didn't rely on her mailing address to assess the property. Under 5096, that's the erroneous information, not her mailing address.
Correct.
Finally, because he was quit claiming it to her, she had the right to file a notice of non-acceptance, and she did not.
Good point.
One question.
Yes.
I'm interested in the discussion of the information available to the county on the question of buildability. Was there a septic system that would work? Was there erroneous information related to it or not? And would that have affected the outcome if what finally became some consensus on the buildability had been reached at that time?
Well, 5096 says that we made evaluation based on erroneous information provided by the assessee. The first person to raise the issue about whether or not it was buildable and a septic could be constructed was Mr. Roberts. It was not Ms. Jones. It was not Shane Crow. So the question, if you want to find that erroneous, then you're looking at his erroneous information, not information provided by prior owners.
And I'd like to just clarify.
Mr. Roberts.
On behalf of the Senator, I would just like to clarify, I think there's a little bit of confusion about the reading of 5096D. Everybody's forgetting the first half of the sentence. The first half of the clause, which Mr. Roberts did not bother putting on his PowerPoint, says, paid on an assessment in excess of the ratio of assessed value to the full value of the property as provided in Section 401 by reason of the assessor's clerical error or excessive or improper assessments attributable to erroneous property information. That erroneous property information is with respect to the application of a ratio, not erroneous information leading to a specific property-specific valuation. The assessor used the correct legal ratio. 5096D and 5096 in general has to do with whether or not the assessor followed the general law in applying a ratio equally, okay, to different properties. It has to do with equalization. It has to do with making a legal mistake, not an issue of interpreting facts. And so I believe that the discussion of whether or not the prior owner may have not gotten correct information to the assessor is to 5096. And the concern that the assessor's office has is that the Board of Supervisors might usurp the new process that it just created by deciding to operate as an appellate review board where it's not entitled to do so. The law does say that once an assessment appeals board makes a valuation decision, how the valuation was determined is when there's facts that are arguable on both sides. That goes to the Superior Court. That doesn't go to the Board of Supervisors. Even if there's a sympathy for the taxpayer, and I believe that is what the law says in this, and I think that's where some of the confusion comes. So I just asked the board to read the entire 5096D in its context before making a decision.
One question on the ratio. A ratio is a relationship between numbers. What are the numbers? What's that ratio composed of so that we can see whether any component of that ratio or the basis for assessing the ratio is based on bad information?
The ratio under Section 401, which is specifically called out in 5096D, is full cash value. And again, I simply give you a little history lesson. Before Prop 13 passed, the ratio was 25%. When Prop 13 passed, that ratio changed to 100% of full cash value. That's the entire ratio. There was no factor applied to the valuation of this property.
Madam Chair,
Yes.
the one element that bothers me about this, and let me preface my remark by saying that I was in full support of the Assessment Appeals Board being set up to do this work for us. But it is bothersome to me because the Assessment Appeals Board, it's conceivable that they made their decision based on this Ron Marlin's testimony that, you could put a septic tank on this property. The gentleman has come to give us ample evidence that there may that reality may have disappeared. I just really don't like being in a position where I don't have the ability to make a right choice, or to make as you call it, a sympathetic. Sympathy can't come into play, but I'm very sympathetic about maybe the sympathetic for the gentleman when the appeals board. It appears on the face of it that they might have made their decision based on an improper piece of information.
Right, and
that's very substantial.
Right, and the law says that if that's correct, that Mr. Roberts does have a sympathetic argument, what 5096 in the case law under it says is that he needs to go to the court and make that argument to the judge. Now, on behalf of the assessor, obviously the Assessment Appeals Board and the assessor felt that they were making a correct valuation determination. And the question is, did they go through a legal process to make the determination? Yeah, they were following the law and doing the job they were set up to do, and looked at evidence on both sides for valuation, came to that determination. And all I'm saying as a lawyer is, in analyzing what the extent of the Board of Supervisors has a right to do under the law, it appears from everything that I've looked at that the Board of Supervisors isn't entitled to make a pure sympathetic decision here, that there has to be a legal basis under 5096. That's all I'm saying.
Okay, thank you.
Common sense doesn't apply as a legal basis.
Mr. Roberts, you had your opportunity. The board is now asking questions. If they have a specific question of you, they can ask that. Do any of you have a question of Mr. Roberts?
I do. I'd like to hear what Mr. Roberts has to say in relation to the last set of presentation. I'm ready to vote on it myself, but I do believe that people have the right to rebuttal in this kind of a situation.
Well, we can go on, then we can have a rebuttal on a rebuttal on a rebuttal.
I agree Mr. Roberts should talk.
I'm not asking you to overturn the Assessment Appeals Board. I'm asking you to rule relative to 5096. An improper address is information. An improper address about the new owner is information about that property, and it was certainly erroneous. Now, the Assessment Appeals Board didn't rule and never will rule on that $115,000 valuation. As of June 11th, 2007, it is never to be discussed again, according to statute. Once 60 days had passed from when that letter was mailed out, it could not be discussed. So that erroneous information denied Kathy Jones the opportunity to request a review by the assessor's office or the Assessment Appeals Board in a timely fashion, forevermore. They couldn't hear it again if you tried to send me back there. Law says no. So they never ruled on that $115,000 valuation. They said, we can't discuss it. 5096 says you can discuss it. If there was erroneous information, there was erroneous information, it denied the appeal, and it allowed an absurd $115,000 valuation to stand. You continue to say the Assessment Appeal Board said $60,000. If you believe $60,000, then you owe me a tax refund because I paid taxes on $115,000 validation, which was allowed to stand in 2006 because of erroneous information. 5096 stand on its own, and it's an alternative remedy, an alternative to going to Superior Court to try and appeal the Assessment Appeals Board. It's an alternative remedy. Every one of those factors has been met. You know the definition of erroneous. Is an address that's more than 8,000 miles away from where she lived erroneous? Certainly it's erroneous.
Okay. Is there any further discussion by this board? I'll ask for a motion.
I'll make the motion again then, and the motion is to grant the appeal under 5096. And am I able, Jim, in the motion to state what I think that it should go back to the original assessed value of $64.85 and then be brought forward from the date it was reassessed?
I think that you need to determine the amount of the refund.
I think that the base should be the $64.85, that it clearly was erroneous to increase that to $115. And it should be brought forward on that basis as the base to what the taxes should be today.
I'll second the motion.
We need to leave here with, if this is granted, with a clear understanding as to the dollar amount of the refund, and I'm not sure that who's going to make that calculation.
Can't we just give you the base and somebody can do the calculation?
Outside of my expertise, I think Leslie should.
I contacted Lynette Norfolk.
Mr. Roberts? Mr. Roberts? Mr. Roberts? Ms. Davis, do you have an answer to Supervisor Tryon's question, please?
Madam Chair, honorable members of the board, if I might. You're making a motion as if you are a local board of equalization, and you are not. The motion I'm hearing is that you're attempting to establish the value of the property, and that is not within your jurisdiction. What you have to do is establish how much should be refunded to Mr. Roberts. All right? Now, having said that, those calculations are not something that we can make in this room. I do not have what Mr. Roberts submitted in his original claim for refund as the total dollar figure. Does council have it? Do you have it in your packet? Because I do not have it.
Well, he establishes a range, I think, of $1,200 to $1,400. Okay, 15. But my point here is that it's just as a matter of due process. This is a semi-judicial process. We need to have some ground rules as to when the argument stops and when we make the calculation. I don't think there's anybody in county staff who has the ability the authority to make a calculation. This board, I think, needs to give a dollar amount.
And so let me be clear about a couple of...
The dollar amount and the calculations based on the original assessment of $64.85 being brought forward with the adjustments since that date. I mean,
okay, but here's the problem, Supervisor
I'm not saying
Tryon.
it should be 64.
The total tax bill that Mr. Roberts paid 2 weeks before he acquired title to the property was $3,808.19. Since then, he's been refunded $1,283.25 through normal roll correction and negative supplemental processes. So his net right now is about $2,600. That's a whole lot different than a $1,200 to $1,400 range. And what I would suggest that you do is come up with your own ratio. He's asking for $1,200 to $1,400. Come up with a ratio and set a dollar figure, because we're not going to go back and recalculate an assessed value that predated Mr. Crow's base year value and factor that forward by 2%. This isn't an appeal hearing. It's a claim for refund.
Okay, as a point of order, Madam Chairman, I think we have a motion and a second, but on the question, Supervisor Tryon, I'd like to ask you, I mean, clearly, if you have a value that you talked about, the 64 or 50 or what it was originally,
85, I think.
But anytime that you have a change of ownership, it triggers the ability to reassess. So applying this 2% per year increase is not correct.
Well, it is until Mr. Roberts bought it, and Mr. Roberts basically paid $6,000 for it, which is even less than the assessed value. according to his...
Yeah, but follow my suggestion for you. I'm inclined to believe that we shouldn't go back and wipe out what our duly appointed Assessment Appeals Board has done. They've established the $60,000 value. I'm still a little confused about how it went from $60,000 to, is it, Mr. Roberts was saying that it's currently at 8. Leslie, can you shed some light on what happened there?
The amount he paid Ms. Jones plus the amount he paid Mrs. Norfolk as back taxes because he cleared delinquencies was added together as his total cost of the property. Let me kind of be as clear as I can here because I apparently am not making my point. You don't have the authority to base your values on this. Your authority begins and ends, in this instance, with how much you're going to refund Mr. Roberts, if you refund him anything at all.
Well, but the refund is based on the base value. So if somebody can calculate from the base value and say this is what the refund is. And I don't know what's complicated about that. I don't know how we're supposed to do that in our heads and say, oh, pick a number between 1,200 and 1,500.
Well, let me give you an example.
Based on what?
Let's say that, let's use his numbers, and I have no idea how right or wrong they are. He says the taxes were based on $115,000, and just because I can do this in my head, let's say you say it's $11,500. That's 10% of what he said. You could say we'll refund 90% of something between $1,200 and $1,400, but you can't give us a range. You've got to give us a specific number in this motion. So if you want to give him 90% of Mr. Jones, you said it was $1,200 to $1,400?
The papers that were filed are $1,200 to $1,500.
Okay, so you could say 90% of $1,350, and yeah, we can all do that math with a calculator. Then you're giving a specific refund, and that's something we can wrap our arms around.
Pick a number, Steve.
I think I have to agree.
$1,350.
There's no one in the county structure who has the authority to make this calculation other than this board.
Right.
So you have to.
But our staff has to make it for us. I mean, we're not prepared to make it off the top of our head at the end of the hearing. I mean, come on, what do we have staff for?
Well, I've been adding up the time that the people who would be normally paid out here waiting for the jail discussion to begin, and I'm figuring we should try to move this as expeditiously as possible. I would propose an amendment to your motion that would make the rebate of taxes $1,350.
I accept that as a friendly amendment.
I have a motion, I have a second. Further discussion. All in favor, say aye.
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 Opposed?
No.
No. Passes on a 3-2 vote of this board. We'll take a 5-minute recess. Meeting to order, please. If you'd like to talk, please go out in the hall. Thank you. I forgot one item, the review of correspondence reports, etc. I'm asking the board to please keep it short. Mr. Thomas?
Yes, Madam Chair. Let's see. I have a Mountain County's Water Resources Board meeting listed here on Friday, but I'm trying to get some research done on our participation in that. I got a bill essentially for our continued membership in that organization, and it's about $1,250, and I'm not sure that I want to go if we haven't paid our dues. And I'm frankly shocked that we have been sent a bill. I don't know what our level of participation has been in the past. I've not been aware that we were paying for our membership. Do you know anything about that?
I don't. I'll have to check into that for you.
All right. But I also wanted to bring up this letter that we got from Phil McCartney about a proposed meeting that would be on February the 18th to discuss the Highway 4 water wastewater agencies getting together. He's asking for 2 members of this board to attend that. Tom?
Yes, I'll be there.
Okay. I'd like to go there as well, but that's not next week. It's on the 18th.
But I think we have the joint meeting with CCWB on what, the 25th?
On the 25th. Okay, that concludes my report this morning.
Mr. Tuffanelli.
I have a Mountain Valley Emergency Services Committee meeting tomorrow in Amador County at the Board of Supervisors chambers there. Again, bringing up that the Oversight Committee is going to give their presentation on their meeting they held a couple weeks ago in the public.
And now into our study session.
Madam Chair, members of the board, thank you. Upon my arrival as CAO, one of the first things the board asked for was a comprehensive review of the status of the jail and sheriff administration project. Since I came aboard in late November, the project has had a change in project manager. I'm pleased to introduce to you Doug Evans with Kitchell, who is our construction management firm. Doug is our new project manager. And we pulled together the county team of different departments, and we are working jointly on this very important capital improvement project. As you can see, Eddie Ballard, I think, gets the award for the most patience. I think Eddie started on this project about 4 years ago, working on the needs assessment. There have been many players, many decisions made on this project to get us to this point today. We have Tom Garcia with Public Works, Shirley Ryan with Administration. We have Michael Justice, who's the architect with PSA Dewberry. Of course, Sheriff Downham, front and center. And we've got Doug, and then, of course, Michael Walker, our undersheriff, George White, planning, Jeff White, building, Janice Elliott, County Council, and Jim Jones, County Council. We have taken lots and bits and pieces of information that have occurred over the last 4 years and put it into a comprehensive report for you today. What I can tell you is that there has been a tremendous amount of progress made, and we'll go over the accomplishments that have occurred to date. We will also talk about some of the outstanding issues that are confronting us, primarily related to AB 900 financing and the state and county relationship in terms of our obligations and contractual arrangements with the state, which have yet to be seen. We have not received our standard project agreements yet, which actually will spell out what our legal responsibilities are. We anticipate, given a notice that we received late last Thursday, that those draft documents will be available after 5 p.m. this evening. And we'll have an opportunity to review those documents with council, as will other AB 900 funded counties. And we'll be participating in a meeting on February the 25th with the Department of Finance, with the Correction Standards Authority, with corrections and rehabilitation, as well as the State Department of General Services. We anticipate at that time a number of our issues and questions will be answered, and at that point we'll have a better grip in terms of where the state might be heading. So with that, I'm going to turn it over to Doug, who will lead us through, and each of us will participate. We'd encourage you to ask questions
during the process
and interact with us, and if there are some things that we want to hold off on, we'll let you know.
Okay, thank you. And just the public's information, I will, after the presentation, open it up for any public comments or questions. Any questions will be taken and will be answered at one time. Thank you.
If I could say one other thing. I can assure you that by the time we get through with this, we will have more questions than we will have answers.
Got it.
This is a moving target. It has been a moving target since we started this process 4 years ago. But our mission today is to provide you with the most current information we have to make the best informed decisions now.
Thank you, Ms. Boyce. Yes, please.
Well, good morning. It's a pleasure to be here. First thing I'd like to do is walk through the agenda that we've set up for this study session. As you can see, we've divided the agenda into 4 parts. The first is an introduction and overview. We want to do a little introduction and a little background to bring everyone up to speed as to where we are today. Then we want to get into a project status, where we go through the status of the project, give you a complete picture of where the project is today with regard to design status, with regard to cost, with regard to schedule and other project issues. Then we want to talk about occupancy and operations, predominantly occupancy and operations cost, and then present a conclusion of the report. So if that's acceptable, we'll move forward.
Thank you.
First thing we'd like to begin with is a brief background. And on November 6, 2007, as everyone's aware, this measure was put on the ballot, whether or not the county wanted to support the issuance of $31 million in bonds for a new county jail, 911 dispatch center, and support facilities for sheriff's operations. And 67.2% of the voters of Calaveras County voted yes to the measure. Since November of 2007, the project team has been working diligently to move this project along and make it a reality. I want to go through some of the items that have been accomplished over the last 2+ years. The first on the list is acquisition of property for the project, which was completed. Once that's done, the initial study and mitigated negative declaration was prepared and issued, which is the document that complies with the California Environmental Quality Act. The needs assessment was completed, and an architectural programming for the project was developed. There was a selection process in which Kitchell was selected as the project manager. A contract was negotiated, and Kitchell was brought on board. There was an agreement finalized with San Andreas Sanitary Sewer District to provide sewer service for both the jail and courts project. And the county and the Sheriff's Department submitted the funding request under AB 900 to obtain partial funding for the project. As part of that, a reentry facility component needed to be negotiated, which was also completed. As part of, or adjacent to the jail administration project is the courts project, and there was a whole series of agreements that were negotiated and executed with the courts in order to make that project a reality. A selection process was conducted for the project architect, and PSA Dewberry was selected. They moved forward with the preliminary design and then moved on to completion of 30% design documents for the project. Initial staffing and operational plans were developed. Those 30% drawings were submitted to the California Department of Corrections and Rehabilitations for their review, which is part of the process. Comments were received and are being incorporated into the documents. The project team conducted a value engineering analysis and a life cycle cost analysis of the 30% design. There was also cost estimates done at that time, and it was determined that the project was over budget. So the team went back in a redesign effort and consolidated, reduced square footage, made the design a little more efficient, and was able to bring the project in line with the project budget. And I'll discuss the specifics of that a little more later in the presentation. I'd like to talk a little bit about the new courts facility. Adjacent to the jail admin project, the state of California, through the Administrative Office of the Courts, is planning a new courts facility. The project is slated to be 40,000 square feet, contain 4 courtrooms, administrative offices for the courts, holding cells, and a secure corridor that goes out of essentially the basement of the courts project and connects to a enclosed walkway that ties into the jail project. And you'll see that a little bit later on the site plans that we're going to present. The budget for the project is $43.6 million, actually on a parallel schedule with the jail and admin building project. Both are slated to hit construction late this year or early next year. So both projects are currently in the design process, and depending on how quickly both projects get through approvals and we get out to construction, one may be a little ahead of the other, but right now they're going to be pretty close to being in the same time frames. As Jeannie mentioned, if there are any questions as I'm going through this, please don't hesitate to interrupt.
Mr. Evans, I did have one question about that. Our two facilities appear to be coordinated, at least architectural style-wise. Has anybody seen what the court is proposing to do? Are they going to have a red barn-like structure or what?
I don't think they're going to design a red barn, but we have had meetings with the court's team, with the project management team, as well as their design team. We've had coordination meetings with regard to utilities. And Mike is a project architect. Maybe he could address the architecture of the courts versus the architecture of the jail.
Yeah, the architecture of the courts building is driven around more of the civic feel. They're using a lot of glass panel, trying to convey a state-of-the-art facility. Our project, as well, we're trying to convey a state-of-the-art facility. However, we're trying to convey a slightly different feel of security, civic architecture, as well as looking at materials for cost effectiveness and energy efficiency. Those are our major concerns.
Okay.
Well, I'm sorry, go ahead.
Well, the thing that jumps off the page is that their cost per square foot is over $1,000 a square foot versus ours at $470 or whatever it is. So anyway, I just wanted to see where they are.
Is their project going to be LEED certified?
I believe it is. I think they're shooting for LEED silver.
Thank you.
Will the jump, will the court project be LEED certified?
We're not going to even get bronze. It's just an editorial on my part.
So we are focusing on trying to put green building components into the project, although not going for the LEED certification.
I know, isn't that too bad? That was an editorial. Please proceed. I'm sorry.
We could double the cost. We could double the cost and get there.
How are you going to drive the cost?
Oh, just give it a rest. I shouldn't have opened the door.
That's right.
Go ahead.
Moving on to AB 900 funding, the county through the sheriff's office has requested funding under AB 900, and in May of 2007 the legislature passed AB 900, which authorized up to $1.2 billion for county jail facilities along with other funding of other facilities, and the county has made application and received conditional award of $26,387,000. The county match and the in-kind match are the requirements of AB 900 funding, and those are the numbers in the application, but the county is going to well exceed those match numbers because we've got a lot of money in Measure J that's going towards the project. So your match is fine. There shouldn't be any problem there. One thing I might point out, the AB 900 funding is strictly for the jail component. So it doesn't go towards the dorm, and it doesn't go towards the sheriff's administration building. It's only applicable to jail, 160-bed jail component. There are some issues I'd like to discuss regarding AB 900. The first, as Jeannie mentioned, is we don't have the final documents from the state, so we don't know what the terms of the agreement are going to be. There's been a lot of discussion, there's been a lot of preliminary information issued, and we've based everything to date on that preliminary information. But once it gets down to getting the actual document, which the state has indicated will be on their website at 5 o'clock tonight, we'll be able to get the county council and really review this document to see what the true conditions of the AB 900 funding end up being. One of the issues we know is out there is that there's an operational requirement that the project be operational and staffed within 90 days of completion. And there's the word fully that's being bandied about. Fully was not in the AB 900 language, but it was in the RFP that the county responded to. And that's created an issue with regard to the definition of what fully really means. And we're hoping that the language that comes out perhaps this afternoon will clarify that. organization, County Sheriff's Organization for the State of California, has worked to get this language reduced in the onerousness of the language, because a lot of it just didn't make sense the way it was originally being interpreted. But at this point, we don't know. We're optimistic that the language will be lessened.
Is there a time frame from the time you start getting funds to the completion date in the language that you know?
Ask that again, please.
Is there a time frame from the point you start getting AB 900 funds to a completion date?
I believe the funding has to be expended in 3 years, but the real issue is we need to get the project agreement, we need to have it reviewed, get comfortable with it, and then get that document executed. And at that point, you'll have a stronger confidence that you're going to get the AB 900 funding. You will have an official agreement with the state that says they're going to, pay this money to the county during construction.
Okay, Mr. Walensky.
You used the term lessening, and I'm curious about the different factors in that. I could imagine that, for instance, instead of being operational within 90 days, we could be operational within, say, 300 days. But what's the scope of the discussion being talked about, and what are the elements of lessening besides the time of completion to staffing up? Are there, for instance, talks about what percentage of staff might be, would meet the standard? There's lots of variables. What's in the discussion now?
The discussion is, quite frankly, that let me read you a paragraph that was developed, and it came out of CSA.
CSA being?
Correction Standards Authority, who's administering 900 and supervises all jail construction requirements. It is our understanding from previous meetings with CSA, the Department of Finance, and the California Department of Corrections and Rehabilitation that because the term fully is not statutorily defined or mandated, that the determination of the appropriate staffing level will be made by the sheriff and county officials prior to becoming operational. It is important that this determination be left to the discretion of the sheriff and county officials to ensure that staffing levels appropriately and safely addresses the facility inmate population. We have to be operating that jail within 90 days of completion construction, but from everything we're getting, we'll determine what the staffing needs to be for the inmate population that we have.
What parameters could you see in relation to this particular discussion? There's a certain minimum level of safety staffing that we've seen in some of the documents and from independent presentations. I guess last time out there were 2 different staffing models that were discussed. How would a change in the 90 days and the definition of fully staffed, what kinds of choices would we have if we got our way in that? And what's the dollar implication?
There will not be a change in the 90-day window. When we complete construction, we have 90 days to be in operating, staffed and operating. This is going to be part of the presentation before.
Oh, okay.
We started his, but quite frankly, the way everything is unfolding and the amount of pressure that's being put on CSA, you have to understand that this staffing and operation element was put in back in the late 80s, early 90s. Pretty much everybody in California got money to build jails. LA built the Twin Towers, and then they let one sit empty for years and years and years. And the reason this is in there is the state doesn't want to provide money to let something sit there and not be used. But the term fully, nobody can figure out where it came from. It's not in the legislative language, it's not in any of that. Quite frankly, when I had discussions with the authority and CDCR last week, the opinion I came away with is if we go over to our new jail with our existing inmates and our existing staff, we comply. It's not that we necessarily want to do that, but it's something we can't do.
Thank you.
I think what the sheriff said too is this is one of those points of shifting sand where prior to last week and prior to the lobbying of local jurisdictions and the Sheriff's Association, the CSA was pretty hardcore on that, fully staffed and operational within 90 days. And quite frankly, a lot of the AB 900 counties said we can't afford to do that. And so I think we're seeing a real shift in their focus to allow us to build some additional beds, but within what we could reasonably afford. And that's one of the discussions that will be ongoing. So.
All right, so this potentially changes some of the numbers that are before us.
Absolutely. And we're going to talk about that as we go through this.
All right. Sorry to interrupt.
No, that's all right. Encourage that. The next issue we're going to talk about is quarterly reimbursement from the state. As I mentioned, the AB 900 funding is only for construction of the jail. It's not for design. It's just for construction. So once we get into construction, the county will be required to pay the contractor on a monthly basis, but the agreement will only allow you to submit an application to the state quarterly. So there'll be 3 months of invoices that the county's going to have to pay and then get reimbursed from the state at a minimum of 3 months plus the time it takes to process that application for payment to the state. Now, they've indicated in the document they should process the payment within 3 weeks. Now, we've allowed 3 months in our interest calculations, so we hope we're a bit conservative. Maybe we're not conservative enough there, but anyway, we've tried to accommodate that in the interest calculations that I'll show you in a few minutes. There's another component and actually in the beginning it won't be an issue because early on in construction you will have Measure J money which you can pay out to the contractor and then it will be reimbursed by the state. But once we get down to the end of the job, that Measure J money will be gone and will be spent. And at that point the county's going to have to come up with some kind of an interim financing mechanism to be able to make those payments and wait for reimbursement from the state. Also, at the end of the project, the state's going to go back the last 20% of the AB 900 funds.
This information was provided and a changing of titles was done. There was more subterfuge than an honest transaction. And I think we should go back to the 6485 and then bring it forward from that date at the 2% a year or whatever the percent is that was actually applied until the present day, because the original reassessment to 115, in my opinion, was not an appropriate reassessment. So I'm for granting the appeal.
Thank you, Mr. Tryon. Are there any other comments from the board? Well, I'll do one then, and then I'll call for a vote. The Assessment Appeals Board said that the value was $60,000. The issue before us is not to make a change in what the Assessment Appeals Board did. The appeal is not to the Board of Supervisors on the valuation, it is to Superior Court. The issue before us is under 5096, was there an error made, a misleading of it? I feel like we are trying to circumvent the decision of the Assessment Appeals Board, and I support the Assessment Appeals Board. I do not feel that there was an erroneous property information supplied by the assessee that is pertinent to changing what the Assessment Appeals Board did. That is not our purview today, so I do not believe taxes are due Mr. Roberts. I can understand his frustration. I appreciate his perseverance on this, but my vote stands as it did before. Thank you. I will take a... If
I could ask you a question about that. If you're maintaining that the proper value is $60,000, how do you, what sort of comment do you have about the previously assessed value at
I don't.
115?
That's not the issue before us. The $60,000 was the value established by the Assessment Appeals Board. That is not the issue. The Assessment Appeals Board is something that this board established to review that. There is not an appeals process to the Board of Supervisors of value established by the Assessment Appeals Board. So I'm going based on the issue before us is under 5096. And I do not think there was any part of 5096 that applies to this. That's a separate issue from the Assessment Appeals Board.
But under 5096, it says clearly that if there was some erroneous information of some type that resulted in a higher than justifiable value, which I would submit that the $115,000 that the gentleman paid taxes on in that 1 year seems to be, on the face of it, unjustifiable.
That's your call, Mr. Thomas. I am going on reading the whole thing. By reason of the assessor's clerical error, excessive or improper assessments attributable to, I am not going to...
Until the project is completed and occupied. So there's a interim financing component that the county will have to address at the end of the project also.
So you're going to bill quarterly, and I'm sure there's a window for the bill date to get there. On a normal contract, a contractor has, say, by the 25th of the month to get their payment request in. And they project where they'll be by the 31st of the month. So they have an entire month. So taking that forward to the quarterly, are we going to be able to bill for the entire quarter through that quarter to apply our bill to the state?
Yes, what would happen is you would compile 3 invoices from the contractor, so the contractor would submit an invoice for the first month, and then you would pay it. They would submit an invoice for the second month, and you'd pay it. They'd submit an invoice for the third month, and you have 30 days to make payment to the contractor. But essentially, they would submit that third invoice. You would begin the payment process in the county to pay that invoice, and at the same time, collect those 3 invoices together into an application for reimbursement that would go to the state. And that's where they said they will pay you within a 3-week period, but we've allocated enough interest to cover 3 months worth of the state processing your application to get that quarterly payment. So then they will pay you for those 3 months, and then it just keeps rolling forward.
Provided they agree on the progress and it's accurate. I'm sure they will send somebody out to, at certain periods of time.
Utilities to the property line for the court's project, and then the courts would pick it up from there and bring it on into their project. So there would be a water stub for the courts here, and then for the jail here, and then we would bring it on into the jail project as part of the construction. The green line depicts the sewer, which goes down through Government Center and connects into an existing manhole on county property, and that manhole ties into the San Andreas Sanitary Sewer District services. The electrical and gas are these 2 lines here, which would tie into existing utilities for PG&E for the gas and PG&E for the electric through the APPA. CPPA, Calaveras Public
Power Authority.
I'm still catching on the acronyms still. Are there any questions on the utilities? One other item, and it's depicted diagrammatically because it's not fully designed yet, is this red line, which represents the collection of stormwater. And there's a requirement to have the runoff in the pre-developed condition similar to the post-developed condition. So the runoff needs to be similar. And there's two ways to do that. One is by mechanical means, where you have storage tanks underground, where you have large pipes that collect the water when there's a rain and then allow it to go out slowly to not have the water just run off the property. The other is what I believe is the better design, which is a more natural design. If we go to the site plan, you can see this green element back here, which is a bioswale. And what that does is it allows water to be collected off of the hard surfaces, go through some collector pipes, some storm drain pipes, and go out into this bioswale, which will retain the water and let it go out slowly. It will also provide a filtering process to take the particulates that come off of the driveways and parking lots and the oil and filter it through natural plants before the water runs off of the project site. It's also more cost-effective to do this. The idea of having mechanical filtration or large underground storage is going to be a costly component. So we went to this method to be environmentally sensitive as well as to save cost. And now I'd like to ask Mike Justice from PSA Dewberry to walk you through the rest of this design and then through each of the individual floor plans. Actually, I wanted to point out one other thing. Here you can see the connection to the courts from the jail project. And we've also got an ADA access to a bus location, a bus drop-off on the court's property that's going to serve, an ADA access will be provided from that court's bus drop-off to the court's project, and ADA access will also be provided to the county project.
Good morning, everyone. Doug mentioned the three major elements to this site plan are the Sheriff's Administration building, the 160-bed jail building, and the 80-bed dorm facility. The reasoning behind having separate buildings is obviously due to AB 900 funding requirements. They call for 15-foot separation of anything built with AB 900 funding from any other buildings on the site. That's one of the driving factors behind the locating of the buildings as they are. Some of the other key factors involved are the requirements or need for an enclosed inmate transfer from the courts to the 160-bed jail facility. Public access to the bus drop-off on the courts, as Doug mentioned. A need and a desire to salvage and mitigate as many heritage oak trees on the site as possible. Currently, we're only removing 4, one of which has already been destroyed by a storm. So we're minimizing the impact to heritage oak and oak woodland on the site. Another key factor in the site design is the location of Native American grinding stones, which you see right there. And probably the final factor is, as Doug mentioned, the bioswale located in the back, which is located to maximize the efficiency of the grading on the site to collect all the water in the rear of the site. Here's the schematic elevation of the 160-bed jail. Main entry being located here. Essentially on the first floor, the lower level of the building, are all the administrative and support facilities, with the upper two levels being for housing. Again, as I mentioned before, materials are being chosen from basically the mindset of looking at cost effectiveness and energy efficiency while still trying to convey civic and public architecture. This is the overall first floor plan of the jail. Shows public entry to the visitation, which is located down here. You see in red are the two major control points of the building. All of the major functions of the first floor are located around that control for issues of sight lines and security. Again, access from the public to visitation is here. Access of outside services to program spaces where inmates will be brought down from the housing levels. It's located here so that outside services do not have to go through the remainder of the jail. Here located in brown, you see the administrative areas of the jail. In the rear of the facility located near the staff entry 2 48-bed units, 2 24-bed units, which are behavioral, special behavioral, and special management units, and 2 administrative segregation units at 16 beds each. Again, in red are 2 main control units. Adjacent to those are the outdoor recreation units, which you'll see in light blue, which are adjacent to each of the housing units. Also, within each day room, we have program space designated for each of the day rooms, which allows access to any special programs and educational programs set up by the county. The day rooms are also sized for internal programs if need be. Moving up to the mezzanine level of the jail. Again, here in the dark blue, you can see the mezzanine level housing units. The light blue is the opens below of the day rooms, and the green is essentially mechanical and support space for the jail. Moving on to the Sheriff's Administration Building, you can see the main entry. Building materials are going to be chosen based on, again, the same factors I mentioned before, and will be consistent from building to building throughout the project. This is the main level of the Sheriff's Administration Building. This is one of the major changes from the 30% design to the current design, in which we reduced the square footage by about 10% on this particular point, trying to maximize efficiency and circulation. The driving factor here is trying to locate all circulation, staff circulation being located in the rear of the building, public circulation and entry being located off the front. Public parking is down here, getting access to records and administration will be off the main lobby here, and access to evidence and evidence viewing, evidence return will be off to the other side. As I mentioned, staff entry is off the back, located off the main common. There's lockers and physical training located off the one side, patrol, roll call, community room, and armory located off the other. Moving up to the second level. Access to the second level for both public and staff will be located around 2 main stairwells with access to Sheriff's Administration offices, narcotics and investigations located in the rear of the building, Emergency Operations Center here, and Dispatch 911 here. And this is an elevation of the dormitory building. This building is going to be kind of a background building to the project. It's meant to be low-key, very low in height, trying to be kind of a background building to the site. Similar to the jail buildings, you see in blue, the day rooms, which another major change from the 30% design was to go from a mezzanine level dormitory to a single level dormitory. So we moved everything down to one level. You can see located around the main control, central main control, our outdoor recreation spaces, the day rooms, each one at 40 inmates, and program spaces located immediately off the day rooms. And then building support back at that.
Are there any questions for the board on this? Russ, did you?
Well, I don't know whether this is a proper time to ask some,
Could you speak into the
I'm just wondering if there would be a later time that would be a more...
They may, but the state's in the past been pretty good about accepting what the county has to say with regard to completion, and we're going to watch that very closely. And we're going to do an application for payment. We're going to go through every line item. There'll be a very detailed schedule of values that's generated at the beginning of the project, which the contractor bills against. So we'll be very judicious.
And will be standard contractor contracts as far as the 10% retention?
Mm-hmm. Yes.
There's no way to project the last payment to them is holding 20%?
the last payment from the state will be the final 20% of your AB 900 money.
Right, so they're holding in contingency the 20%. I'm saying the last contractor's payments, if there's some way to structure their contracts, so those last payments be parallel to what the state is doing to us.
We could look into that. It would probably be a little bit outside of the norm, but at the end of the job, you should be holding 10% of the contractor's total contract.
Ask some specific question about design details of the floor plan of the project and relative elevations of the buildings. Are you going to have a general round of questions later, or should I just jump into it now?
I think if there's questions related to the floor plan, now would be good.
All right, Mr. Justice, on a prior iteration of this proposed layout, there was about a 12 or 14-foot differential between the elevation of the administration building and the jail. I see that grandiose stairway and everything has been eliminated, but I'm also looking at and trying to find a justification for why there's a 2-foot differential between the finished floor elevation of the jail and the bed dorm.
Trying to balance the cut and fill, trying to get
But if you're moving equipment, linens, food, and everything across that area, I mean, I see it where you get a kind of jog in the sidewalk going from one to the other. But is that, are we going to have continuing difficulties with that 2-foot elevation change over the years?
The length of the sidewalk that you see making that connection there will be ADA compliant at a maximum of 1 to 12 slope, which should be really manageable.
I think there's a couple of things that play in there. One is the adjacency with the courts. So we've got to maintain an elevation so that connector to the courts is relatively flat. And the other is we've got to take into account the topography of the site and try and balance the cut and fill of the site. That's something that we can go back and look at a little bit more before we move into 50% drawings.
One of the driving factors is the spot elevation of the lower level of the jail building, or I'm sorry, the courts building next door. We are trying to maintain as minimal slope between our connection at the jail over to theirs. We know what their elevation is. It was only recently established as kind of their final datum line, which therefore set our datum line here for the jail building, and everything is essentially relative to that. As we move into the next stage, we'll be finalizing the elevations and then kind of fine-tuning things.
Okay,
that 2-foot difference may not be 2 feet.
Yeah, well, what caught my eye was that on that north boundary, or north wall of the dormitory, you've got a bunch of equipment rooms and stuff that open out there. With you've shown with detail what that sidewalk is, but you would also require a sidewalk along the whole perimeter of the building. Yeah, okay. The other thing is, with focusing on costs, and every square feet costs a fair amount of money, I just was struck by the fact that in the women's locker room in the Sheriff's Administration building, just by, I know that I may be perceived as picking pepper out of fly specks here, or fly specks out of pepper, vice versa, but 33 women's lockers versus 125 men's lockers. Is that what is the proportionality there? What's driving that?
We work pretty closely with the Sheriff's Department to evaluate their needs and their future growth, both male and female staff, and then these were the numbers that we all felt comfortable with.
On the sheriff's side of this thing, we're trying desperately to build out for 20-year needs. And that was what we came up with.
Okay, I can see how we would very easily fill up the jail in maybe 2 years, but filling up this, or building it, that we wouldn't fill it up in 20 years. I'm just thinking out loud. So that's all I have right now.
Could I say something about that 5 to 15-foot buffer? That's another issue the state sheriffs have tried to take on with CSA. That was an absolute hard and fast rule since we started this process. And now suddenly, 2 weeks ago, we get some language back that this is a general rule and may be altered given particular site conditions. The proposed project with less than 5 to 15-foot buffer will have to be evaluated on a case-by-case basis. So they're starting to get very flexible on that, and hopefully after this meeting on the 25th, we'll have a little more clarification. That makes our life a little bit miserable. San Joaquin, with having to have that separation, it's about a $5 million hit here.
Any other questions? Please proceed.
Let's talk about the finances for the project. First thing I'd like to talk about is the funding. There's predominantly two sources of funding for the project, Measure J and 8900. You can see the amounts here. The Measure J bond was passed in the amount of $31 million, and the difference is the bond sale costs that were deducted from the actual funding that's available for the project. Moving down, you see net interest income of $1.2 million. We've done a cash flow calculation that we believe is conservative, that in the early stages of the project generates interest income from the Measure J funds that are currently invested. But as we get into construction and run out of Measure J funds and the state's not paying you as quickly as you're expending funds, there's a negative interest component that plays into that. When you net those two, along with the carrying cost at the very end of the project to carry that remaining 20% balance that the state hasn't paid you, it all nets to a $1.2 million positive to the project. So $1.2 million in interest income for the project. And we believe that's a conservative calculation. The other is the reimbursement from the courts project. And in the agreement between the county and the Administrative Office of the Courts, there is a payment of up to $500,000 for the cost, reimbursement of the cost that the county is incurring to get roads and utilities and improvements to the site. That represents the upper limit on the court's fair share of those improvements that the county is paying for. Moving on to the budget side, you have in your packet a what's called a cost control report. And this is a much more detailed assessment of these categories. But essentially, the budget is broken down into three categories. Construction costs, which represents almost 80% of the budget at $46.8 million. Then consultant costs, which are the costs for project management, for architecture, for geotechnical consultant, survey consultant, environmental consultant, cultural consultant. Unfortunately, we're in an era that there's a lot of consultants required to construct a project of this nature. That represents just under 13% of the project cost. And then there are other project costs such as testing and inspection. Also included in that is the fees for utilities such as PG&E and the fees that were paid to San Andreas Sanitary District. That represents just under 8% for a total of $58.9 million, which matches the budget that's established here on the screen and in your cost control report is in line with the available funding for the project. Now let me go to these next couple of slides. In the budget, there is $820,000 allocated for Mountain Ranch Road improvements, for construction, for some design, and some testing and inspection. But it's estimated at this point that the cost of Mountain Ranch Road improvements without right-of-way acquisition would be about $3 billion. And that's a project cost, including construction, design, testing, inspection, all in cost. So there is a difference there.
Excuse me, before you leave that immediate thing, what right-of-way in this new, you were looking at a new way off of Mountain Ranch, are there right-of-way issues relating to that?
The alternative alignment being contemplated currently is on county-owned property. So acquisition of right-of-way for everything past Cove Street, but not necessarily cost the county any additional funding.
Sir, before you go to this one, I'd just like to, for you to elaborate on your statement about on the AB 900 funds, and we get paid in arrears, and at the end they're going to reserve $5.2 million, which is 20%, and that we will run out of Measure J money as we do the jail. But Measure J is basically to do the sheriff, also to do the sheriff administration building, the 80-bed and the 80-bed facility, et cetera. Can we not build the 160-bed jail first so that we don't run out of Measure J money and then wait till we get the last, the 20% that's reserved paid back in before we do the 80-room dormitory or the sheriff administration building?
Yes, you could do that. You're saying, I think, build a 160-bed jail, and then when that's done, build the dormitory and the sheriff's administration.
And then we don't have the cash flow problem. Would that not be accurate?
You could do that. I think there's some concerns there. One is, typically costs go up, and you're going to move those costs into future years. Right now, we're anticipating being done with construction in early 2013. You can now start a construction project in 2013 and take it out a year and a half after that, so you'd be out into 2014, maybe into 2015. So you're going to have some escalation costs. But the real issue is the administration of this project, which is currently 23 months of construction administration. Now the architects and the construction managers are going to have to administer, say, 48 months worth of construction. So I think we could do a cost analysis and we could take a look at that value, which includes the jail, the dorm, and the administration building. And the state's going to be holding 20% of just the jail. So they're close. You would definitely be in the negative. But they're close. And we've factored the interest component already into the interest calculations. So we've got carrying costs built into the plan for the funding of the project.
Mr. Evans, some of the contracts that I used to work under that were long duration contracts that had built in that there would be a 10% retention through
to do something about cash flow here.
Right.
And so it seems to me that you should at least analyze it and see if that one of the things we have to do, if possible, is figure out how to get this project to go forward. And the way I went home and read this document, and it was like, holy smokes, we're falling off a cliff. And then your comments today have modified the comments in here to some degree, particularly on the operating costs and the like. But it seems to, and maybe I'm getting to my summary here before you guys do, but it seems to me that at some point to proceed, the board's going to need to know where the end game is and that we can get there, and that the county, upon arriving, will be financially solvent. And this document does not reflect that. And we need a document that reflects that, I think, before we...
In issues of cash flow management, there are options for some short-term financing. As you know, we have issued trans tax revenue anticipation notes to handle cash flow for county operations, and that is usually a 12 or 13-month timeline to get us through the first half of the year before the property tax revenues come in and pay at the end. We've had some just very, very preliminary discussions with our financial advisors and financial strategies as to what options do we have. They said a trend naturally, but we recommend it because of that usually 12 to 13-month timeline. But there's also something called a grant anticipation note, very similar to a trend, and it has a 3-year timeline. So without doing any analysis at this point of how much that again would need to be or what the cost would be associated with it, we do know that there is an option out there for a 3-year financing to help with health issues.
Thank you.
We were talking about the essentially the difference between the $820,000 that's in the budget for mountain ranch road improvements and the $3 million that we're anticipating those improvements to cost. One of the thoughts, and Mr. Garcia will be talking about that a little bit later, is applying for federal stimulus funding. There's a good chance that the county would be successful, especially in light of the fact that you've got CAL FIRE, the hospital, the government center, CHP, and DMV all on a road that we'd be applying for federal stimulus dollars for. So, it should have a good chance. But we know that's not a for sure thing, and decisions have to be made now to move the project forward. One of the things that we are going to do, and we do this anyway, is identify what we call bid alternates. Because estimates are just that. They're estimates. They're an estimator's best educated guess at what the project's going to cost. But they don't really know. Maybe climate changes and things happen. So what we would normally do is identify a series of bid alternates. These are items that if the project bid over budget could be not included in the project. And they need to be very carefully identified. Two criteria. The first thing need to be items that are of some substance. You don't want to not include an $89 item. That's just not going to affect the project. So it needs to be a substantial cost. But the second thing, it needs to be something that, although it is a item that the sheriff's department feels is they would like to have in the facility, is important to have in the facility, if it came down to whether or not you have money to issue the contract and build a facility or not, it's something that could be dropped out of the project. And one of the things that is at this point slated for an ad alternate is the dormitory building. So at bid time, you could make a decision as to whether or not the dormitory is in or out. And that would definitely cover the deficit between those two items. But as we move forward in design, we want to identify other items to put on this additive alternate list.
I'm assuming that the $3 million anticipated road cost is predicated on building the alignment all the way down to the red barn. But wouldn't it be less expensive if you took that dotted line alternative and entered there?
The $3 million is actually based upon the dotted line alternative.
Really?
From Highway 49 to the dotted line, yes.
Wow. So it's conceivable that it might not be simply an alternative. I mean,
I'm sorry?
If the cost is the driving factor here, it may be the preferred alternative, sounds like to me. So.
I can weigh in on that. Currently, the alternatives have not gone through rigorous environmental studies, so we can't state right now what the preferred alternative is. From an economic standpoint, this one looks promising.
Well, I personally like it because it takes advantage of the fact that the road would go up some otherwise undevelopable terrain. So you couldn't put a building there anyway. So.
And the last item with regard to the budget and the bidding of the project is we don't really know what the bid time is going to be in the fall of 2010, which is the current scheduled bid time for this project. The bid climate has been advantageous to owners over the past number of months, but it's just we don't know what we need to keep in mind. Moving on to the project schedule, I apologize for the graphics here. You have copies of that graphic in your report. And I summarized some of the major milestones just to do them quickly. The current schedule, and I need to qualify that, the current schedule is based upon the architects and the project team going back tomorrow morning and full steam ahead with the design of this project. So that's what the schedule is based upon. Now, depending on what direction you give us, that can change, obviously. That's the current. But that's what's currently reflected in the schedule. Based upon that, we anticipate receiving bids in early October and issuing a notice to proceed with the contractor in mid-November. Now, the reason it's so long in between there is we have to go to the state and get their concurrence. We have to come back to the board and get your blessing. So there's a little bit of a bureaucracy we have to go through in order to award the project and get the construction going. Based on a start in November of 2010, the construction would be complete in October of 2012, which is about 23 months. That includes all the site work, all the road work, site improvements, and construction of the 3 buildings. Once that's completed, we would go through a shakedown and transition period in which the sheriff's office would take control of the building. And they begin to operate it, they get familiar with how everything works prior to moving in any inmates. And then for the schedule, it's December 20th and all the way out. They'll probably move in January. But late in 2012, we would envision occupancy early 2013 of the facility. Once the new facility is occupied, we would go back to the old facility, do asbestos abatement and demolition of the old facility, and then on April 2013, the project would be complete. So that's the current schedule. Other project issues, let's talk a little bit about the staffs and utilities. We had meetings with San Andreas Sanitary District, and an agreement, as I mentioned earlier, has been executed, so we're moving forward with a design that meets their requirements for sanitary sewer for both projects. We had a meeting late January with the Calaveras Public Power Agency and PG&E to talk about gas service and electric service to both projects. We submitted an application to PG&E to begin the process of designing the requirements for the electrical service for both projects. Calaveras Public Utility District, there's been meetings with the district. We're trying to schedule another meeting with their engineers to go through get the PSA Dewberry's engineer and their engineer together to start talking about the specifics of the design of the water system. Environmental mitigations is an issue. There is approximately 0.21 acres of potential wetlands on the project, and the plan now is to take that wetlands. We have to go through the Army Corps of Engineers 404 permit process to do that. The reason we need to do that or want to do that is there's parking that is designed to go in the wetlands area, and there's also that bioswale in the back, so a major portion of the wetlands will be converted into bioswale in order to save cost and make the project a little more green. The 57-acre site that the county purchased has elderberry bushes on the side, which are habitat for the valley elderberry longhorn beetle. And there is one tree or shrub on site that is in the protected area, which is 110 feet around the shrub, is within, we want to encroach in that area a little bit. So we've got to work with the state agency.
5% of the project, but as you got toward the end, the retention was dropped to 5%, you know, for large contracts. So do you anticipate that ours will be written in that fashion or a consistent 10%?
That's something we could have discussion on. It's not uncommon to reach 50 or 75% on a project, and if everything's going well, the county could have the option to reduce the retention to 5%. And it's really the county's option, or the county could say, no, we're going to hold the entire 10% to the end of the project. Now, often that will affect how the contractor figures cash flow. So, there's no free lunch. He's going to factor that into his bid.
Yeah, that's the kind of balancing act that we have to consider, that we may attract some more favorable, more competitive bids if we promise that cash flow will not be a problem for them. So, but we could also be in a bind at the end of the job if we don't have funding.
And the intent there is that the contractors that have done site work or foundation work very early on in a project to get permission to either encroach in that area or transplant or take the elderberry bush. And we don't know the specifics of exactly how that's going to conclude, but that's the direction we're moving. The last item is the oak trees, and I talked about that. We've been working to minimize the take of oak tree habitat and really work to minimize the take of heritage oaks. We've got it to where they're trying to take 4 heritage oaks. One has already been destroyed by the winter storm where we had the snow a few months ago. So we're working to mitigate that through the various mitigation measures that are identified in the ISMD report. culture mitigation. Mike also talked about the grinding rock, which is on site, and that's being protected. There's a safe area around the grinding rock that's going to protect that. There's one other cultural mitigation item that may come into play. We don't know, but the county hospital had a burial graveyard adjacent, more to the east, we believe, but it's potential that could come into play as we start getting into construction. If we do, there's mitigation measures in place to deal with that. Traffic mitigation. Tom, would you like to talk a little bit more about the traffic mitigation component?
Certainly. The funding available for the roadway right now is $800,000 budgeted. 500 of that comes from the state and local. The project costs that are being looked at exceed that amount. We're looking at additional funding opportunities. One of them is a Tiger grant. That's a transportation investment generating economic recovery. It's very competitive. We applied for a grant in the amount of $4.4 million. That was to include all of the improvements on Mountain Ranch Road and the signalization of Mountain Ranch and Highway 49, or intersection improvements of Mountain Ranch and Highway 49. The results of that funding request will be available on February 17th. We're cautiously optimistic, but again, it's a national grant. We'll see how we fare. Another funding opportunity is an annual appropriation through the Congress. We have submitted our application to Senator Feinstein's office on Friday. We'll be submitting the application again to Senator Boxer's office this Friday, and Assemblyman Lundgren's office the Friday after that. The information on the status of those grants should be available about right around June 1st. We'll know the status and where we sit. We are spreading out the requests for the appropriations over several years. If we ask for the entire lump sum in 1 year, we'd be competing with the likes of the Bay Bridge retrofits and the big ticket items where we might not fare so well. If we drop our request to an amount, I believe our first request was for about $670,000. That would carry us through the right-of-way acquisition, the environmental and engineering on the project, and the next appropriation, we'd be asking for the entire amount of construction funding. We would be seeking a local match for this first round of that $800,000, or a portion of that $800,000. In addition, we'd be using RIM funding for this. That's the reimbursement from RIM would be 13.7%. So there's some money available for this RIM project. We're trying to maximize the amount of local funding that applies to these federal grants so that we're well above the 11.5% that's mandated. Somewhere in the range of 25%. It looks much better for our grant application if we're putting in a lot of money, a lot of local funds. It shows that we have great interest to get this project done. The grant application also stated that this was the #1 priority in the county after the intersection improvements of 1226. And so it was the #1 priority for a non-state highway project, which bodes well for our application. So again, we're cautiously optimistic. We can't say it's money in the bank, but we'll be able to keep you apprised of both these grant applications and others that we'll be seeking.
Any questions or comments from Mr. Garcia? Thank you, Tom.
Good morning. George White, Planning Director. There is a planning and zoning entitlement process that's still yet to be completed to support this project.
And that consists mainly of amending the general plan, the existing general plan on this property to be consistent with the proposed public use, amending the zoning regulations that apply to this project to allow for the construction of this public facility, and then a conditional use permit that will deal with the detailed aspects of the jail facility itself. The process is a two-step process. It's probably one you're very familiar with. The collected entitlements will first go to the Planning Commission for their review, and a recommendation will be forwarded from the Planning Commission to the board at that time through a notice public hearing process, at least one public hearing, I would think. At that point, the recommendation of the Planning Commission would come to the board. The board would hold another notice public hearing, and at that point, hopefully would approve the entitlements, and we could then move on to the permitting and construction phase.
Any questions for Mr. White?
Yeah, Mr. White.
Oh, I'm sorry, go ahead.
I'm just, you threw me there when you said that we'd have to change the zoning to allow these uses, and then you went further to say you'd have to have a conditional use permit.
That's correct.
Well, why, if the zoning is proper, why would you have to have a conditional use permit?
Within the framework of zoning permitted and conditionally permitted uses, and in this particular case, I think we've already made an assessment that under the zoning that we're contemplating, a facility of this type is still a conditionally permitted use, so it would still fall under that requirement.
Okay, thank you.
Thank you.
Moving on to occupancy and operations.
This is probably part of the report that gives local jurisdictions the most heartburn. So the sheriff's going to lead this discussion off here with his latest news.
Yeah, when our new CAO showed up, we talked, and I told her that I really wanted to focus my attention working with the state and the State Sheriff's Association and trying to resolve some of these issues that I knew had the potential for basically closing down the project, particularly the staffing issue. What you're going to hear is basically the same thing you've heard about 3 times before. You're going to hear costs associated with staffing and operation that is absolutely the ultimate total maximum capacity of inmates, total maximum staffing, everything. The costs are not approved, but there's something we need to shoot for, and some kind of a timeline needs to be built to get there at some point. And the importance of that is we don't want to run just a warehouse. We would like to offer some rehabilitation, some programs to try to keep some of these people maybe from coming back. It's something we just, because we're throwing people out so quickly, we don't even get to introduce them to programs anymore. So we do need to get at a level where we can offer these kinds of things. Well, I think we made a big stride in, well, what you're going to hear is scary, but the reality is what we've just gotten from CSA, and that will absolutely be confirmed on the 25th of this month, that it's up to us how we safely staff it with the inmates we have. Now, certainly it's going to be incumbent upon us to control the inmate population. Along with this, we've introduced legislation that I'm sure will pass. We've been working on it for a while to allow us to use the electronic monitoring program on pre-sentence people. Right now, most of our jail is pre-sentence. It's ridiculous. But if we get the electronic monitoring program, so we can use that on pre-sentence people. We can get back into our work release, our work furlough programs, a number of programs that used to work very successful. Now nobody takes them because it's easier to get booked and released and get into a program. We think we can manage the jail and we can staff it. I'm hoping not with exactly the same staff we have, but if we have to, that's what we can do. I mean, there's certainly, if we're housing 80 inmates instead of 65, there's going to be a bigger food bill, there's going to be a bigger PG&E bill, but we can grow into this. this thing. We don't have to spend $2 million right up front and grow into it. The other thing, working on that meeting on the 25th is going to be very important for a couple of reasons. We're going to get a lot of stuff in writing for a change. But one thing they're looking at very strongly is changing the AB 900 bond sale process. This system has been set up, so the money was supposed to be reimbursed to counties out of a kind of an infrastructure fund that the state had. Originally, the AB 900 bonds weren't even slated to be sold until projects were 80% complete. And then they would be sold, that fund would be reimbursed, the counties would be paid off. They're talking about selling the bonds for specific projects, which I think 23 months. The contractor's going to hold, the general's going to hold 10% of their money, and they may have finished in month 3. They don't get paid until month 26, 27, 28, when the project is totally closed out. So, there's some reasonableness to that.
And the intent is, when it goes out for RFP, to all 3 buildings for a bid?
Yes.
Not separate? Okay.
That's the intent at this time. That would make sense.
Any other questions? Okay. Thank you.
Okay.
Well, this is the $100 question. How does the state of California's current budget deficit, which is at $19.9 billion, impact the issuance of the bonds and the state's plans for the issuance of those bonds? And at this point, we don't know the answer to that. Will the state's cash flow be a problem? Will the state's credit rating be a problem? We just simply don't know. So again, we hope we have some enlightenment by the Department of Finance at the end of the month.
Eugenie, she thinks it would be very helpful to the county. If they do sell bonds specifically for our project, then we know that money's there. We know we have that bond. So those are the kinds of things that are being looked at. And in March, at the CSA meeting, this started back in December, I think, several agencies, including us, made application to Correction Standards Authority because there is leftover money from round 1, AB 900 funding. And it's within their purview, just the committee. All they have to do is say yes. They didn't let us apply for design monies, only construction money. It is in their purview to pay for design monies. We've made an application for about another $6 million, which would certainly reimburse us for our design monies, that sort of stuff, which would be extremely helpful. The other thing that we've done, and just within the last week, we've submitted a grant for federal government. I believe it's through Homeland Security. For $1 million grant to build an Office of Emergency Service. If we're successful with that, we can back Measure J money out and use that. So we are looking for every funding alternative. We're looking for every way in the world that we can get this thing to work without financially killing the county. And I think we're well on our way to that. So having said that, I'm going to let Shirley and Eddie scare you to death with these numbers.
I just have a question, Chairman. At what point will we know if we'll receive the $6 million or some portion of that?
The information's been in front of the CSA board since December. They should be able to make that decision at the March meeting. But it's kind of unfortunate, the study session being held today with our contract supposed to be posted at 5 o'clock tonight, and this meeting for the first time will be in the room with the Department of Finance, General Services, Correction Standards Authority, and CDCR, all the players in the same room on the 25th. So we know a lot of good information's coming.
About what their intent is with regards to the lease revenue bond issuance, because certainly we'll be interested in when we might anticipate those bonds being sold.
Moving on to the project status. Currently, the schematic design on the project has been completed and the drawings are what's determined a 30% completion level. Let me kind of back up a little bit and talk about the different phases of design. There's normally 3 phases of design. A schematic design, where you do the big picture components. You get the floor plans identified, you get the general elevations, and you site the buildings or building on your property. Then you take a pause and you review that to make sure it's definitely what you want, because you don't want to change it in the next phase. That's also called 30%. Then you move into design development, where the architects will develop all of the detail of the interiors. They'll do interior elevations. There's a lot of information that's put onto the drawings. So they take the drawings to the next level, and that's called 50% development, 50% document or design development. Then again, you have a review and approval process to make sure that's correct, make sure you're on budget, and then the architect's released to do construction documents or working drawings, which is 100% documents. And then again at the end, there's a review period. So we're currently at the completion of schematic design, or 30% documents. Okay. In this project currently, there's a jail building which is 65,000 square feet. It consists of 160 beds, administrative offices for the jail function, intake booking, programmatic spaces. There's medical food service, laundry, and staff areas. The adjacent dormitory building is approximately 11,000 square feet with 80 beds of dormitory space and, again, support program facilities. And then the Sheriff's Administration building, which is 38,000 square feet, that has Sheriff's Operations support facilities, contains evidence and records. It has offices for investigation and narcotics, as well as other offices. Locker rooms, contains a space for the Emergency Operations Center and 911 dispatch. This is a area map which depicts the location of the Sheriff's Administration building and jail in green, and adjacent to that is the AOC site, which is the Administrative Office of the Courts, where the court would be. Obviously, this is Government Center here. We have Highway 49 over here. The prior plan, or the original plan, had 2 accesses to the site, one going up Government Center Drive and the other coming up Gold Hunter Road. We're currently looking at an alternative to this to bring in access, and that's why it's dashed, from Mountain Ranch Road just to the north of the main entrance to Government Center, going behind this building, the legal building, going behind the existing jail, and routing up to the 2 projects. Now, the reason these are in dashed lines is they haven't been flushed out yet. It's conceptual right now, but that's a thought that's on the table. I'm going to talk a little bit more about that a little later in the presentation. This is a site plan that depicts schematically or diagrammatically the utilities. But we wanted to kind of give you an idea as to how the utilities are going to run. The blue line is the water line, and it'll tie in somewhere on Mountain Ranch Road, possibly not here, but probably down here, and run a 12-inch line from the public utility in Mountain Ranch Road up to the courts project and the jail project, and then an 8-inch line will go back down to Gold Hunter Drive and tie into a dead-end line on Gold Hunter Drive. That does a number of things. It improves the system for the water district because now they have adequate pressure at Gold Hunter Drive. It's a little bit low, but it also creates a loop for the jail project. So you've got 2 points of access for water. If there's a problem and one side got shut down, you would actually get water coming in from the other side. So that's a real good way to design the water system. The agreement with the courts requires that we provide services for each or maybe about 3 weeks over this meeting.
So all the AB 900 counties will be at that meeting too, correct?
Yes.
It's not just for Calaveras?
No.
Okay.
And the AB 900 counties have all basically petitioned correction standards authority for the design. And it's kind of weird if you look at the funding that was receive and what's left over, if you look at that leftover money and look at your design, it almost matches up perfect with everybody. So we're hoping they make the right decision. We'll find out.
Thank you. So Shirley, Eddie?
Actually, I was just going to tell the board, this is information that you were presented back in June during a study session from Chin Planning. We just included it in this report so that you would have some continuity from what you heard in June to then what, in fact, the administrative office and the sheriff's office, both Eddie and Shirley and Jeannie Middleton, crank through specific numbers, the local numbers. The Chin Planning numbers are really based on nationwide trends. As you can see, it increases. It is based on a 240-bed facility, fully staffed and operated, assuming that there's 100% occupancy. And again, this is the additional personnel cost of $3.53 million, again, for a 240-bed facility, assuming that you have programs and you are fully occupied and operational, for a total annual increased cost of $6.1 million. So we just bring that to your attention. You've seen that before, but we thought we should help make that transition from what you heard before to now.
But that in building it cost effectively, so the cost of the jail, running the jail goes up significantly just at the 160 bed level. If we have full occupancy of 160. Fully operational.
Ballard, I know we're talking about millions and millions of dollars here, but what struck my eye is on the Chin report, she was expecting that you would
Could you tell us what page you're on?
Oh, back on the page 27, where it talks about increasing from the current 3 cooks to 5 cooks. But in all your analyses, whether it's 160 or 240, you're assuming that we're going to be able to operate the new facility with the same amount of cooks as we currently have? Is that
yes, I believe that we could. And fully operational. And some of the ideas that we had when we was putting this jail project together was the programs for the inmates. And part of that would have been, teaching how to cook or being in the kitchen. So pretty inmate intensive, assisting within the facility itself. Based on the 160 bed and the analysis that I did, and based on using inmate workers and trustees the most efficient possible way we could, I believe that we would maintain yes.
Okay, good.
Steve, do you have any questions?
Actually, I do have a couple of questions. I'm a little curious about our basic presumptions here. For instance, on the personnel costs, we look at, I think the statement was that we're calculating on the basis of today's expenses. Today means today, or when you did the calculate, what date are we talking about?
Actually, the budget employee costs were, Jeannie and I put together what the current staffing is with the step increases in the longevities at 2012-13. In addition, what we took was we cleaned these up, and I have what the estimated PERS rates are going to be for that fiscal year, so we included those rates in. We looked at the new staffing, and we said, were we going to get consultants in with Oracle, probably within house. So when we budgeted their rates, we budgeted them at an E staff in order to give us that flexibility. All other staff were budgeted at an A staff coming in the door as is county policy.
Right, I understand the steps, but my two concerns in this regard have to do with the PERS costs, which we anticipate going up in the next couple of years. They have a smoothing process that means that the worst of it will be drug out over a little bit of time, and that seems to hit us right when we're starting up here. I'm not sure that the PERS calculation is exact on that. And the medical
2012-13 is what the PERS have sent us as their rates
for 2013. And medical benefit costs, we're just saying it's going to stay the same.
We have used the current health benefit costs simply because we know that they did not go up this year. We're able to maintain the costs as they are, so we use that. And there's really no way to project what those costs are going to be because it's based on our modification rating, our usage, the cost of the industry, so it becomes a little difficult to determine what that is.
I do personally project costs this way. Last time there was a health care reform discussion back in the Clinton administration, the costs during a couple of years of that dialogue were held at very minimum by the industry. And what we appear to be in is another debate about this after this meets its end. Generally speaking, the trends always have been that the increases are make-up increases for that period of time in which the industry held back.
It will depend on whether or not health care reform is through.
Yes, well, I'm noting that either way, my guess is the insurance companies will have their way with us, and that those calculations actually are significant in employee costs. I have a second issue that has to do with our revenue and staffing cost projections. It seems to me the county has little or no control over how many inmates wind up in our jail, that is a function of the courts. And that I'm unfamiliar, and maybe you can inform me about jails that have been built where judges don't, where there's a backup and a history like ours, where they don't get filled up pretty quickly. Secondly, I've noticed that the state of California, when we bank on revenues for leasing, the state of California is an unreliable partner in its current budgetary condition. And so with two factors that are so out of our control, I'm wondering how we managed to come up with such solid figures on what we expect both in revenues and what space might be left.
San Benito, when they first built their jail, managed it. The sheriff arbitrarily decided what he could staff safely, and that's what the inmate population was. If you'll take a look at Fresno right now, the Fresno County Sheriff said, I can't afford to staff this, and she emptied 500 beds. And those beds are going to stay empty because she can't afford to staff them. And I'm the one that's constitutionally obligated to run that jail. If we determine that 80 beds is all we can staff safely, that's the people that are coming in.
But the state has to agree to that.
No, they don't. Not one bit.
I mean, on the new jail, because we have to change the wording. From
the information we have now is it's staffed and operated regardless of how many prisoners and how many staff we have in there.
That we can't live with.
Correct. But certainly locally, and it says right in their language that it has to be left to the sheriff and county officials to determine what can be staffed.
So, it's no different than what we have now, what Supervisor Walensky said. The judge sentences people to 6 months or a year, and they serve 2 hours or 2 weeks, and they're out. So it's just the same thing pushed forward.
Well, until certainly we would go in at a minimum. Eddie thinks we can operate 112 beds. I usually use 80 beds as the formula, but 112 beds would be very, very close to the same staff when we can make it work. Now, we're not going to be doing a lot of programming. We're not going to be trying to fix a bunch of stuff. Because we don't have the staff to deal with that.
Steve, do you have some more questions?
Yeah, I had one more question. On the what's being termed as support program services, I noticed that for the jail building and the Sheriff's Administration building, there was quite a list of the operations that would go into it, the departments. For instance, on the jail building on page 4, they refer to support services including administration, intake, booking, medical, food service, laundry, and staff areas. On the Sheriff's Administration Building, we have evidence storage, record storage, locker rooms, offices for various departments, Emergency Operations Center, dispatch, and 911. However, in the dormitory building, we're talking about support program facilities, and it doesn't really list a whole lot of stuff. I know that's, as the sheriff described, an important area where we have the possibility of reducing our 54% return rate. I'm wondering, has there been any discussion on that? Do we have the same level of detail about programs would go in there? What other county, what space for county departments such as substance abuse or social services, job training programs, et cetera? What are we anticipating, and what space will that take up?
Well, within the dorm, the dorm area, pretty much with the exception of being cells, it's an open bed area that has the same programs, spaces, and all that. It'll also be used, for alternative work release programs. And so, if you look at the dorm, we have our multi-purpose or program rooms within the dorm. It mirrors, so all the programs that we would do within the main housing unit would also be conducted within the dorm.
Okay, and that's in those two classroom-type situations?
And if you go back into the main hallway of the jail, there's another program room that's within proximity to the dorm. So we've tried to keep everything. We need the first floor. Yeah, so there's another one there. So all of our programs can operate for the dorm out of the downstairs and near the public lobby with access to any outside entities that will help us in our programs.
All right, but we haven't yet got the same kind of detail on the listing of those entities that we do on the internal operations.
In this particular thing, sir, no, it's not. Within our program statement that we did, it's listed within the program statement.
All right.
I have a question. A couple questions here. Number one, on page 3, it says in the second paragraph, the state has raised a question about the legality of the county utilizing bond revenue as a match to the state's revenue bond funding. Does that include Measure J?
Yeah, that question came to us, and we were told that we might receive a letter shortly here questioning whether we could use Measure J to get what we believe our current cost would be. And again, like Dennis said, we looked at the cost for a 240-bed facility and a 160-bed, assuming full occupancy and operations, including programming, which we believe is essential to a progressive jail.
Like Jeannie said, when I sat down and to do this analysis based on this project, I didn't look at the one that we provided you in March of 2008. I didn't look at the one that we provided by Champlain. What I did was look at our floor plan. I looked at what our mission statement was, and I built a staffing study based on the criteria of fully staffed, fully occupied, and fully operational. And a lot of that come into play when I came to the actual staffing analysis and the numbers that we ended up running and how
AB 900. We don't believe that's an issue. Every piece of paper that we submitted to the state for AB 900 application made it very clear that we were using Measure J funds. I guess the issue was whether bond money could match bond money, but we think that's not going to be an issue. We think that was...
Well, that I think should get resolved
early
on
that will be resolved
with the state.
Yeah.
So obviously, if we can't match Measure J money, we don't have a project.
The fear was Measure J money was going to be secured by the new jail facility, which is going to secure the 8900 money. But Measure J is not secured by the jail, it's secured by individual parties.
It's a general obligation bond.
Correct.
It's not secure.
Only one person got a bad drain and fought this out.
Well, it would be nice to get over that hurdle.
I think that's the reason for the question, but we're working with bond counsel to make absolutely sure that it's not a problem.
Okay, the other one I had is, you had in here the talk as soon as the new facility is completed, that we have an obligation to demolish the existing facilities. I did not see that as any line item, and as I missed it, as the cost of doing that. Is that part of the project cost, or is that a independent cost, and if so, how much is that cost?
Yes, the cost is included in the budget. If you turn to...
Okay, that's fine. Just tell me the amount, as long as it's in there. What was the amount, do you know, for demolition?
It was $436,250.
Just to remove it?
Demolish it, abated.
Okay, $436,000. Okay.
That, you had that as a 10-day process?
No.
It said April 1st through April 10th.
No, that was completion of the demolition and abatement on April 1st and completion of the project on April 10th. The actual demolition would start back in January when the old jail is emptied out. So...
maybe I'll just go through my...
Yeah, go ahead, Tom.
List, if that's all right. Madam Chair, I brought this up earlier, that just the cash flow implications of these quarterly payments, and then waiting 30 to 90 days after the quarterly submission and the $5.2 million retainer. If we don't, I mean, somehow we have to address the cash flow issue. That has to get addressed. If my suggestion or thought doesn't increases cost to the point, it's not a cost-benefit relationship, that it seems to me before we go forward, since those are such big numbers, we're talking quite a few millions here, that needs to be addressed before we make sort of a final commitment to the project. I guess another significant issue for me is how far are we going to get into this project before the state sells the AB 900 bonds. We're doing this all on the assumption that we're going to get this match from the state, and we could get quite far into this process and have the state decide to either delay or not go forward with the AB 900 bonds. The condition of the state is obviously dire. I don't know what the interest rates would be. I mean, we're basically almost junk status on our credit rating. We're going to have a change in gubernatorial leadership as a consequence of the election in November, with what the new governor and his whole staff taking place sometime in January of 2011. I guess one of my major concerns is trying to get some commitment that's irrevocable if we are to continue. I don't know how you do that, and maybe it's not possible to do that, but I could...
Well, I think it starts this evening at 5 o'clock with that draft contract.
With that, okay. I mean, to get down the road and then have AB 900 disappear would leave us in a very precarious position, I think is rather obvious. I think we do need to, and maybe you guys can do it through refining, but we're, the $3 million for access versus the $822,000 available is a substantial amount of money. I know Tom addressed it, and maybe we can use RIM funds, and maybe we can do different things, but I think when this comes back, I think, we need to have a pretty clear idea of how we are going to fund that, or plan A, B, and C, so we know it will get funded. And it's not maybe we'll get, TARP money or stimulus money, or maybe we won't. We need to have at least a definitive, it seems to me, answer as to we can always go here, whether it be RIM or whatever, so we know that we don't have a gap, and if we can get federal or state money, then that much the better, and that would free that other money up for other projects. The sheriff has talked about the operating costs, and I think that's absolutely critical, that we have to have the discretion at the local level, basically the sheriff, because if they say we have to increase operating costs at the time of opening the jail, I don't see, frankly, how we go forward. I think also if that discretion is given locally, when I say locally, I mean most likely the sheriff, I think that also takes away the $600,000 or $700,000 in additional costs to train the folks before the jail opens if we have to be fully funded. So I'm assuming both that $600,000 and $700,000 in training goes away, because we can start with our current personnel that are trained or close to being. I mean, it'll be a new facility. There'll be a learning curve, but they're trained, as opposed to the $600,000 or $700,000 that we would have to up front in training and the hiring process in order to fully staff it upon within the 90 days of completion. So I'm assuming all that gets addressed within your conversations with the discretion in staffing being left with the at the local level. I also am uncomfortable using any assumptions for renting out space. I mean, you know, we're short space, but we don't have any money to rent out space, and I don't think anybody has any money to rent space other than the state. And quite frankly, if the state releases those prisoners from the state, that's probably a more logical date to answer, or see if we can bridge some of these questions. Now, having said all that, it seems to me there are some issues that have to get resolved that, in my opinion, could be sort of deal killers to the project, and maybe. I think saying suspension of the jail project is too strong a word, but I'm not so sure that we wouldn't be wise to delay some, and there's not much on your sheet to have a delay of spending a lot more money until we meet again in March and have some additional answers. You had mentioned that according to the schedule, well, my God, tomorrow you go out and you hit the deck of running with some additional proceeding on your chart here, which is, I guess, I'm looking here for the middle of February, so you're talking about some design development and some regulatory.
Came together. So please keep in mind, 240 beds, fully staffed, fully operational, with the goal in mind of the very beginning when we put this project together, what we wanted to do as an operational philosophy and mission statement for the programs and everything that we needed to do. So that's how this was built: fully staffed, fully occupied, fully operational. And if you have any questions on operational components, I'll be glad to answer those and what that means.
And as you can see, that means an increase to 26 positions for a total staffing of 48 positions, which is only 2.1 difference than the 10 planning report. When I met with Eddie and Jeannie and we walked through the cost, we looked at what it would cost to do in the existing jail, based on salary benefits and services and supplies currently. And then we looked at a
Reviews. I'm assuming the regulatory reviews don't cost a lot of money. I don't know about design development, but it would seem to me it would be wise not to make a significant amount of new expenditures until we know that the deal sort of killer issues have been resolved. And to me, I think the toughest one, I think all of these are obvious to all of us, and hopefully reasonable people will sit down and say this is reasonable and get it worked out, whether it be cash flow, the match of the bonds, the operational costs, etc. The one that I think we won't have an answer to, and I don't know what to do about it, and that is when they're going to float the AB 900 bonds, and if they're going to float them, and after they get the money and float them, well, all of a sudden they suspend payments like the governor did last year on capital projects. I don't know what to do about that, so it would be nice to try to get some, and I'm sure you can't, and particularly with the change in administration, so there's not even a particular commitment to seeing a prior administration's commitments through to completion. I don't know what to do about that, but I think that needs to be very actively discussed with the state, that we have to have something, and some sort of irrevocable commitment, because otherwise they could put the county right into insolvency if they pulled the chair out from under us late in the day.
The contract will be posted tonight, and the meeting on the 25th are going to be very critical.
I'm sure every other AB 900 county, if they didn't float any bonds, would all be insolvent also. So, but still, it's a head of a risk.
I would imagine that contract is going to be, the draft version will be hitting tonight. And imagine Jeannie and Jim will spend hours and hours and hours on that, sending them back revisions or whatever. So that's going to be a big first step. But you talked about meeting again first part of March after that February 25th meeting. I don't have the date for the CSA meeting in March, but it would be nice if we could have it the week after that meeting, so even more.
It's the 25th. There's only 28 days in March, so I'm assuming that. What day of the week is the 25th?
It's Thursday.
25th?
I think so.
6, 7, 8, I think. Tuesday would be March 2nd then or something.
Yeah, my guess is how they'll work it is they're asking counties, they're going to release this draft, and then counties will have an opportunity to read it and submit some questions to them. Then they'll have this public meeting, they'll take more comment, they'll have some discussions. My guess is then they'll go back and there'll be additional revisions. I'm not sure we'll have them by March the 2nd, which will be the next meeting. I mean, that's typically how it works. But I mean, we should get a sense of how receptive they are and what the actual language says. It's really hard to do a risk-benefit analysis for the board when you're not looking at any language, because always the devil's in the details.
Right. Dennis, how many AB 900 counties are there?
I believe there's 11.
Okay.
We met with the governor a week ago. I think it was a week ago. And people got pretty direct with him.
When you say we, who's we? The 11?
State sheriffs. California State Sheriffs.
Sheriff's Association, okay.
And we pointed out to him how ridiculous it was to pass AB 900 as emergency legislation over 2 years ago, and now one shovelful of dirt's been taken in. And it was almost like the light bulb came on. There's all these outfits that haven't been saying a whole lot are suddenly getting very, very active. So we think they have direction to make some of this work.
Yeah. It seems to me it would be in our interest, in our best interest, and I think the other 10 or 11. But it seems to me all the AB 900 counties should be tied together at the hip. We should be meeting together and then speaking with one voice to the state, if at all possible, and making sure that whatever the risk exposure is, it's equal for each county, so the state can't, divide us later. We're in a lockstep together, and I'm sure you probably are working on that. Okay. That completes my comments, Madam Chair.
I have a process question. I asked my questions but have not yet made my comments on the project. I was wondering whether we were going to have public comment before that time.
We are. Are there any other questions, comments from the board at this point?
Yes, Sheriff, I heard what you said about that it is within your prerogative to decide how many prisoners or how many tenants that you could manage here. If we could put the floor plan...
Russ, could you speak into the microphone?
If we could put the floor plan of the jail back on, please. That's a 160-bed facility. Now, just help me visualize how you could section off and leave portions of this unused. Is that, if you have a smaller population than 160, what you're proposing, just so I can understand, you would have conceivably half of that gray area would be unused. That would allow you to do, say, 80 people. Is that correct?
In some of the analysis, and there needs to be a lot based on after CSA and this other information gets back to us, is what I can do and I can maneuver within the jail to do. But kind of the beauty of how we set up on this thing was the initial, when we started looking at how we're going to be able to operate this and on through, and kind of looking at some different contingencies on what we can consider operational. What CSA says fully operational is dependent upon us. The beauty of it is we got 48 bed dorms. Now, operationally, what we can do within those dorms is I can divide this dorm into 4 sections, which is 12 people in each section. So when we divide these operationally, I can't give a lot on how we would do it right now because I haven't proceeded through the analysis of it, but we have to look at the operational things as far as visiting, feeding, and programs and all those types of things. But the beauty of it is I can get 48 in here, divided up into 12 section units and be able to, use whatever staff I can figure out to do the operational elements of it. We got a 24-unit one here. We've got a 8-bed unit, and a 24-bed unit. Between these 3 right here, there's 112 beds that we could potentially grow into, depending on a bunch of factors. But what we do is we have the ability operationally within this to be able to bring in the inmates we need, administrative segregation, other types of things, and how we can divide that up, how we can do the females, how we can operate. So there's so much room for us to do in here. And analysis would have to be done so I could, really sit down and talk to you about it. But there's a lot of room that we can do based on what the sheriff is trying to accomplish.
But what I'm trying to establish here is whether it's realistic that you could build the whole facility, and I see the economies of scale, of building the whole thing now. But can it be built and conditioned in such a way that you could essentially mothball 25% of that floor plan?
We could determine we do not have the staff to open that off.
Open this one here?
Okay.
And it stays the way it is.
Okay.
Now, we may, for CSA purposes, we may use the program room, we may use the outdoor exercise room, we may do some of that stuff just to be in and out of that fund. But certainly we could say we're not filling those beds, we can't staff.
Okay, now, fully exploring all options, would it be possible that you could, at the same time, build the 80-bed dorm? I want to, follow my logic here. Could you leave half of that facility unused with 80 people in it, and also have the ability to rent out 80 beds over in the dorm?
Yeah, the dorm is ours. The dorm, we can do what we want with that, and we certainly, We cannot rent out 8,900 beds, 160.
Yeah, right.
That is absolutely forbidden in the 8,900 legislation. But the 80-bed dorm, we can
Well, I guess
leave it empty, we can rent it, we can do whatever we want.
stated another way, I just want to make sure that we're not painting ourselves into a corner where we have to fill the jail before we can rent the first bed.
No,
So,
absolutely not.
okay. Now, the other thing that makes me wonder here is, I haven't done the homework to know what your percentage of female population is as your overall percentage of the population in this jail, what you would anticipate it to be. But it looks like to me that logically you would, if you had one female incarcerated there in one of those 24-bed units, it would dedicate that whole 24 beds to that female, right? Or, no? Okay.
I mean, again, it gets down into the operational aspects of how we're going to do that. There's just all kinds of things we do. Just, I can have females in a quarter section of that. It just depends on what ends up happening. When I work with Doug and I work with PSA Dewberry Mike, you know how we can do something like the vanity screens and things like that. So a pod does not necessarily have to be all males or just one female. The most important issue that we need to just keep in operationally is the administrative segregation.
140 bed, fully operational, fully occupied, fully staffed jail. And based on that, we came up with numbers for those based on proposed staffing for salary and benefits using our local rates. We looked at all our services and supplies. We included everything. We included things that are normally not in the sheriff's budget. Those are utilities, because those are usually out of the utilities budget and recouped from through 87. Facilities management, which is buildings and grounds. We looked at A87 costs because those are going to change, even though they aren't in general fund budgets, they are a real operating cost. So we tried to cover everything that we could possibly think of that would go into that budget. And as you can see, an operating cost of $6.8 million. Additionally, we looked at revenues, and Eddie and you provided me with some proposed rental bed space, if you want to call it, in dorms, and we calculated that out at about 63.4 occupancy rate initially, with revenues of nearly $1.6 million, leaving a net operating cost of...
That we would have to really monitor and make sure that they're within their own specific area, because they're a little more high security, higher management.
Okay. But my comfort level with moving forward with building everything is I'm a lot more comfortable knowing that we have the option of using the term mothballing for a while. You talked early on about building your administration building for projections of what the needs would be in 20 years. Well, I can see that this, using that same logic, we would build the jail and keep a goodly portion of it empty until we need it. So.
I think everybody's lost sight. In fact, we even lost sight for a while until Eddie kind of hit me upside the head with it the other day. The primary reason we designed and wanted to build that 80-bed dorm was to build to 2020 needs. So our county doesn't have to go through this process again if they fill up that 160 beds in 2 years, 3 years, whatever. But looking at it, in addition to growing into it when the county needs those beds, looking at it as a revenue source is that's probably been more of a focus the last year than the original intent.
Okay.
Steve?
I had a question about the medical benefit, or I should say the medical staffing costs. Obviously, it goes up when you hit 100. But at what point do we actually trigger that? Is it upon building a facility that's X number of beds, or is it upon having to staff 100 beds or more? And if so, how does that fit into our plans?
Actually,
it's 1.472.
Lieutenant Hubbard did a good job on researching that. that when you get over 100 beds, I can't remember specifically how the language is written, but it led everybody in the country to believe that you had to have 24/7 medical care. Not true. You have to have 24/7 medical available for an emergency room doctor. When Hubbard went to CSA, he got a letter from them basically saying that because of the close proximity of the hospital, that covers us for the 24/7 emergency room doctor being available.
In that case, I'm looking at page 28 of our report here. And it does appear that medical cost estimate is up considerably from what it is now. How, if we can do basically what we're doing now, what's the basis for that cost increase if we're not doing 24/7?
Well,
it was based on 16 hours per inmate per day, fully occupied jail.
Correct.
Which is our current cost for... All right.
Any other questions from the board? I'd like to open it to the public, and then I'll come back to the board to give staff direction. I have a 5-minute rule.
I'll be very short, I'm sure. We're building another building. I noticed all through the years Calaveras County has built really ugly buildings. This building is ugly. The mental health, those ramshackle manufactured buildings are ugly. Even the Wilfrod building down there, it's right in the middle. Every time you drive down the road, you see this horrible monstrosity.
Does that mean you also think the board's ugly?
Huh?
You think the board's ugly?
No, the welfare building.
Oh.
What did I say?
Bonnie, please proceed.
Okay, God only knows what I said. Okay, forget it. What I want to ask is, this new building is really modern. It's not very attractive. It doesn't reflect anything about Calaveras County. It's not rustic. It's not Western. It's Victorian. It's another cold, stark building that just looks really awful. Does anyone put any, I mean, it's millions of dollars, any input into the design to make it aesthetically pleasing instead of big, ugly glass and concrete? That's my only question, is why does it have to look so ugly?
Okay, thank you.
Well, it may not be.
Steve, I mean, Dennis, we're going to just hold the questions till the end. If you want to comment on Bonnie, we can do that.
I'd like to say these are all wonderful questions, and I'm glad that we have such a group together bringing them up so we can wash them out and everything and come up with the good solutions. I just had something that came to mind. The community garden is supportive of our farm to family, and will that go away? I hope not. There's an awful lot of energy and volunteer work that it's hard to see on the maps where everything kind of falls.
No, it's not in where the master garden is.
Okay, and then when you talk about demolition, some people may think this is ugly, but it's functional. And I'm wondering, is this building going to be demolished?
No.
Just the jail.
Jail. Good. That's what I thought. Well, we could really put this to use. I was just afraid it was going to go away. Thank you.
Thank you. Any other questions or comments from the board? Or for staff? Thank you.
5 minutes, Gary.
You have to remind me, right? Gary Caldwell, Valley Springs. Obviously, since this pamphlet or report was just passed out this morning, I have not had a chance to read it. But I did want to say that I appreciate the board holding a study session on a project that I'm sure, as far as dollars and cents, is going to be the largest expenditure of funds here on a project in Calaveras County for decades probably. And if you combine that with the court building, it's probably going to be the largest dollar project in this county for 100 years. And so for that reason, you need to have discussions about it. One of the aspects that may be a byproduct of this new jail facility and this increased capacity is perhaps maybe now the district attorney will choose to prosecute more criminals instead of plea bargaining them and releasing them early and letting them out on the street. Maybe if he has room in the jail, maybe he'll actually prosecute some criminals. With respect to the budget, and I might say that typically Supervisor Tryon and I rarely agree on getting the biggest bang for the public's buck. And one of the things that he brought up was doing the project in 3 separate phases, doing the buildings individually. Normally I would say economies of scale would dictate that you just do it all at once. But with the indication that the state, at least on the jail, because that's the part where the AB 900 money goes, is going to withhold 20%, which if I'm looking at the correct numbers here in the cost at completion, about $23 million, that's about $4.6 million they're going to be withholding. That will more than pay for the cost, according to this number, of the dormitory. So there may be some validity in the suggestion by Supervisor Tryon. The other comment I had was there's an item there in the budget. This is the budget page on page 22. It says off-site road improvements. I assume that the majority of that must be Mountain Ranch Road, if not all of it. It says $660,000. I just heard a number this morning of $820,000, and then on the screen up there I saw a number of $3 million. Good Lord. And then an application for $4.4 million, I think Mr. Garcia said he's applied for. This number seems to be like trying to grab Jell-O. They ought to settle down on some number. At least somebody ought to have some idea of the scope of the project. And the other thing I was going to ask about, with respect to roadway mitigation, down in the bottom where it says project funding, it says $500,000. Where's that $500,000 coming from?
The courts.
It's coming from the court?
Yes.
The court's part of the mitigation.
How nice. The interest, it says $1.2 million on the Measure J bonds. Hopefully there's no arbitrage going on here, since that interest calculation apparently is going to also help make payments, it appears, from what this gentleman here said. The one thing that I heard here was actually 3 things: state-of-the-art, energy efficient, and green components. And I have forwarded to Sheriff Downham an email that I received from the Public Utilities Commission, because I called the Public Utilities Commission about their rebate program, and it particularly does apply to public agencies. Talks about if you install solar energy, you will receive a rebate. This happened to be electrical energy I was inquiring about. Presently, the rebate is $2.80 per watt. Now, I have no idea the design consumption of electricity in this building, because I'm not an electrical engineer, I'm just a civil. But I think that this needs to be looked into, and I'm really disappointed that none of the supervisors in your questions have asked about installing photovoltaic cells or solar water heating. Keep in mind, this is a facility that's going to be operated 24 hours a day. Those lights are going to be burning. All the electricity is going to be consumed, and that no one can anticipate, perhaps. And also, they've got laundry facilities and a dining room that's going to use a lot of water. Hopefully, that you will not just suggest, that you will demand that the architect investigate the inclusion of solar energy components in this design. And there is federal money available for that. In addition to what PG&E says, and all you have to do, I'm not a energy consultant here, but all you have to do is go to the PG&E website, and I just downloaded it yesterday. It has to do with the rebate program for energy efficiency. And they will give you rebates, and it's not...
Over $5.2 million, and that is an increase of $2.58 million over what the existing jail would cost to operate, fully staffed, fully occupied. Then we did the same thing with 160-bed jail. And I'm sure the staffing study was the same. We looked at an increase of 22 staff. We looked at the same salaries and employee benefits for 44 FTEs, services and supplies minus the 140. And we reduced the revenues because we wouldn't be ready.
Not a tax credit. This is a rebate.
Gary, I have to tell you, the PG&E program does not apply to Calaveras County because we're a public power agency. It will apply to the courts. They will be a PG&E customer. We will not be a PG&E customer.
So that means you cannot receive any of these rebates from the Public Utilities Commission?
We cannot access those funds for PG&E funds because we are not a PG&E customer.
That's the 280.
What about this PG&E $200,000 connection fee?
PG&E, do you want me to? You know, I said we'd wait. We'll answer those questions.
Okay. Anyway, I see it in the budget, $200,000 for PG&E connection.
They charge us.
And there is a local certified, I didn't realize that there's a national certification for photovoltaic installation here in this county in Avery. Name is Victor Gilio. I probably mispronounced
Sol
it.
Sierra.
I did mispronounce it.
Sorry.
There's a couple in Iona, one in Pioneer, so you could perhaps get a local contractor to be involved. There's also $6.9 billion, I should say, nationally to make government buildings energy efficient. And there's also grants and low-cost loans available under the stimulus bill for energy efficiencies. I just read in the newspaper about 3 months ago that, in the Stockton Record, that the city of Tracy received $400,000 and some to retrofit the existing city building.
Those bed spaces. So that helped in that operating cost of $5.37 million, and that's an increase of $2.7 million. So it's actually more cost-effective for like 220 bed jail with the additional revenue from dorms than a 160 bed jail. We also looked at pre-opening costs. In discussions with the Sheriff's Office, concern was to do certain staffing 6 months in advance of opening and what those additional staffing, training, hiring costs would be. And so we calculated those, and it was the hiring of the sergeants, the corporals, and active correctional officers to train those and get them in place 6 months prior to opening so that they in turn could participate in the training of the additional staff. In that, we didn't see any increases to services and supplies because we're not in the facility yet. We're simply looking at the hiring and training costs, and that's the increases to services and supplies. We did both for 160-bed jail and 240-bed jail. We also looked at the service administration building. Initially, there's no increase in staffing, so there were no increase to salary and benefit costs or a lot of services and supplies. What we did look at were the things that would be impacted by a larger building, one of which is custodial costs, and we estimated based on square footage that it would require a custodian to provide the necessary services for the sheriff's department. We included some services and some custodial supplies in that number. We also looked at facility maintenance costs. We used an industry standard of 1% replacement for that building and to build that in. And we looked at utility cost increase, and that would be for, we used estimated usage and what the rates would be based on historical data for an increase of $280,000.
We thought it was important to give you the cost for both the 240 and the 160 fully occupied and operational, given where the state had been with their requirements. And now that's shifting, and now, the game may change if, in fact, they actually really allow the sheriff to decide how many inmates and how many beds to open once the new facility is completed. And that's something that, unfortunately, we just don't have the answer for right now. But still, for long-range planning, I think it's important that you see the dollars attached to a larger facility.
And I like that, it is long-range planning, and it's 240 beds fully occupied. That's assuming that in 2013, we're going to go from an average daily population of 76 inmates to 240 inmates. And, that's a short period of time. There's a lot of assumptions to make. They're perfect storm.
Do any of the board members have questions for us?
No. Well, I'm just looking at your figures and your revenues on the 240 bed, which is page 30. And those revenues at the 240 bed level of 1.599 million is renting out the entire dormitory.
It's an occupancy rating of 63.4%. Renting out 63.4% of beds.
And so that's why when you go into the 160, it reflects only 152,910.
Yeah, that's because you can't rent out, there's no dorm beds to rent out.
So it's based on constructing that dormitory. It was one of the options during the bid to leave it out